All right, if you are just joining us here on the Atlanta News First Plus live stream, I just want to show you, this is a group of protesters at Georgia State University, outside of Georgia State University, and you can see the banner. It says, "No Cop City." We have our Rachel Aragon headed to the scene, and she's going to be kind of gathering the latest on the ground on this story. But just for a little bit of context here, this comes on the heels of nearly 24 people being arrested and charged with domestic terrorism after what is being described as an organized attack outside the Atlanta Public Safety Training Facility just yesterday. So investigators, of course, they actually ended up detaining many more than that, more than 30 individuals, but they say that the group was carrying and using fireworks, Molotov cocktails, shields, and while they were advancing on officers who were patrolling the scene. Police say that actually people were attending a nearby event and were actually caught on camera changing out of their clothes and heading over for that event, which took place last night, resulting in the detainment of more than 30 people, and now today 23 people are facing charges. And you're just looking at kind of that is the helicopter now, so we lost signal there, but you know, we were giving you those aerial views. So these are the suspects that I was mentioning who were arrested and charged with domestic terrorism. Police saying that they're from 15 different states. Only 2 of these people charged are actually from Georgia. But I want to show you some of the video that really tells the story of what was going on at the time. This brand new video showing really the size of the crowd during these violent protests. Atlanta Police Chief saying approximately 100 individuals involved in all this. And they quickly overwhelmed police in that area on Sunday night. So again, police saying that this group was using fireworks, they were using Molotov cocktails, they were carrying shields, they were advancing towards officers who were patrolling the scene and basically overwhelmed officers on the scene. And actually, the chief of police was addressing the city council, the Atlanta City Council, just last night, and actually commended his officers, saying that they showed great restraint, adding that they did make several lawful arrests. But earlier in the day, we also heard from opponents about this facility speak out, and just like we're seeing these protests right now. Let me go ahead and play some of those interviews for you.
Individuals that may use this week to bring further attacks on public safety, on property of this government and private property in Atlanta, Georgia, will be arrested, and they will be placed before a court.
We will not stop fighting injustice, no matter the consequences. Drop all the charges on the protesters. Stop Cop City now. Defund the police.
Yeah, so you're hearing both sides. You're hearing for calls to defund the police, and we were showing you those live images of that protest happening, you know, just downtown, where those calls are being echoed. But I just want to let you know, remember I showed you this, these images of the 23 people who have been arrested and charged with domestic terrorism in that so-called, or describe, as police describe it, organized attack outside the Atlanta Public Safety Training Facility. Obviously, you know, defense attorneys for these individuals would not call it that, but there is a court hearing for them, which is expected to take place really at any moment now. So I just want to let you know that's the other thing that we're watching right now, is what's happening in the courthouse, where we can expect these individuals to be arraigned. But you know, this is an ongoing matter. It's been going on for quite some time, as we've been reporting to you these ongoing tensions about so-called Cop City and this training facility. Remember yesterday, if you joined us on our live stream, we were bringing you a press conference by faith groups who took issue with this new training facility for a number of reasons. They wanted an investigation into the death of Manuel Tehran. They wanted a closer look at that, and they had fears about kind of how the well, basically militarization, as they described it, and also some concerns about just kind of the change to the natural environment, deforestation, and so forth, but a lot of issues surrounding all this. But again, this is the latest video that we've got in that shows really what happened in this clash from Sunday night in what police are describing as this organized attack outside the Atlanta Public Safety Training Facility. The crowd here estimated to be around 100 individuals, according to Atlanta police. And again, police said that this crowd made their way over from another event, many of them, and were caught on camera even changing clothes to kind of prepare for this so-called attack. You know, I'm saying so-called attack because if you're the defense attorney, if you're on the side of these protesters, you know, you don't see it that way, right? That's not what they're going to call it. But police are describing it as an organized attack outside the Atlanta Public Safety Training Facility, what opponents do describe as Cop City. So this is just the ongoing issue that we've been watching, and you know, as I'm up here now, I showed you these images of these 23 individuals. Now they're being charged with domestic terrorism, and we're waiting for them to formally be arraigned in court, and we're going to take you into court as soon as that happens, something that we are keeping an eye on. But I do want to take the opportunity to kind of catch you up on a little bit of other news that we're following as well. So do you remember this story out of Douglasville, this very unfortunate story? Look at these two young teenagers. So now there's a $20,000 reward being offered for information leading to an arrest of the killer of these two teens. As we were reporting to you on Atlanta News First Plus, these teenagers were killed at a birthday party over the weekend in Douglas County. There was a home where this party was happening on Talkeetna Drive in Douglasville, where more than 100 teens were gathered, and the shooting happened. And we got a chance to speak with Chanel White, a mom of one of the victims. She says she dropped that little 14-year-old girl who you're looking at off at the party, her daughter. Minutes later, she got the phone call that her daughter had actually been shot and killed. Let's listen.
Found out who was smoking the weed, but you should not have let no children out your door knowing that your child had a party, because you are now responsible for every child that came in your home. You should have made sure them children got back home.
We can't take responsibility for, you know, children that's going out with guns and just murdering people at a random. That's not my responsibility. My responsibility is to make sure your child is safe while they're here at my home.
Yeah, so that's the mom of one of this 14-year-old girl, one of the victims in that deadly birthday party shooting over the weekend in Douglasville. And again, investigators are looking for any information about this incident, who might be responsible. They're trying to find that person. They're offering $20,000 in a reward for any information that does lead to an arrest. And I should add that Douglas County investigators say the homeowner who hosted the party is not facing charges, and that's because the incident actually happened up the road off of her property. That's where the shots were being fired from. So that is the reason for this. Also, another story that we're following out of Gwinnett County, where two families say that they're really relieved. They say that a man who was terrorizing them, posing as an officer and actually robbed them at gunpoint, is now in custody. Atlanta News First reporter Bridget Spencer has more on this story.
It's really hard to imagine what was going on through these victims' minds as this was all unfolding. Now, the suspect is being held here at the Gwinnett County Jail this morning on a $13,000 bond. Our partners at Telemundo spoke to one of those victims in Gwinnett County who chose to remain anonymous for her safety. She told us what happened to her. Now, police just arrested 34-year-old Christopher Michael just days ago after he allegedly impersonated a police officer and broke into two homes last fall in Lilburn and in Norcross. One of those victims we spoke to says she has not felt safe ever since the attack, and she says the impersonator showed up dressed as a cop, zip-tied her hands, and held her at gunpoint.
We didn't sleep here like for about 2 weeks, and we went to like family house because we were scared to be here and sleeping here because you don't know if they are coming back.
Now, it also is very possible that there could be another arrest made in this case, so it's not over just yet. Now, police tell us Michael was able to get away with a Ford F-150, thousands of dollars in cash, as well as smartphones. In Gwinnett County, Bridget Spencer, Atlanta News First.
All right, our thanks to Bridget Spencer for that story. Just want to let everyone know we continue to kind of keep our eyes on not only the protests happening surrounding the Atlanta Public Safety Training Facility, but we are waiting for a hearing to get underway for these 23 people expected to be arraigned on charges of domestic terrorism related to an attack outside the Atlanta Public Safety Training Facility, what many people call Cop City. I want to bring up now these live images, and you see this is a sign from a protest downtown happening about this new facility. You know, we've been covering these protests for months now. This is outside Georgia State, you can see. And this comes on the heels of what just happened Sunday that I was mentioning for those of you just joining us, where there is what police described as a coordinated attack on the Atlanta Public Safety Training Facility, what opponents are calling Cop City. More than 30 individuals were actually detained at the time, 23 of them being charged with domestic terrorism as of today. But for right now, I mean, the important thing is that it does appear to be peaceful. The protest seems to be peaceful, unlike the scene that we saw on Sunday night, which was violent. So we have our reporter on the ground, Atlanta News First reporter, Rachel Aragon, gathering some information and talking certainly to these protesters. And one of our crew members, you can see, you know, down on the ground, walking around, getting this live video for us so that we can get an up-close look at what the atmosphere is like, what's going on here. You see, it looks like there are several officers standing by, presumably just a safety precaution in case things do become a bit heated or potentially even violent. But for right now, everything seems to be peaceful, and hopefully everything does remain peaceful. But yeah, another protest underway after these arrests. So we are kind of hearing that our Rachel Aragon is standing by, and hopefully we're going to be able to get a chance to do a bit of a chat with her, and she'll be able to give us a live report. She's just kind of getting there, and you know, there's a lot going on. Rachel, can you hear me at this point? I think Rachel is probably working to get a connection so that she can deliver a live report to us. I'm going to guess, because I see the camera just pointed, you know, in a static position. We're looking at the ground right now, but I think that's because our photographer is probably trying to help her get organized so she can actually give us a live report. But okay, now we see a little bit of other activity. You can see, you know, it looks like officers standing by, and just in case things are to take a turn for the worse. But it does appear to be peaceful. Rachel, can you hear me? I can hear you. Rachel? Oh, okay. Rachel? Yeah, Rachel. So
can you hear me?
Yes, I can hear you now. And you're live streaming, just so you know. So
okay.
Don't tell me any secrets. It's on broadcast right now. But Rachel, it's a little bit staticky and fuzzy. I know there's a lot of activity, but if you can't get your microphone a little closer.
Sorry, it's a little low, Joy. I'm not sure if you're trying to talk to me. But basically, this is the remnants of what we saw a march for about 50 or 60 or so protesters that were gathering around downtown off of Woodruff Park. They were marching towards the Atlanta Police Foundation building. We're seeing a few more of those still here that are talking to other people as well. But their main, though, message today, several of them, was to get the attention of the Atlanta Police Foundation and Mayor Andre Dickens. A lot of them had marched in this area, though, but you're also seeing plenty of Atlanta police officers that were scattered throughout most of this area. When they were marching, there were several different streets that were blocked off for quite some time, but just to stress again, this was all peaceful. Many of them have already dispersed, but you are seeing plenty of Atlanta police officers downtown near Woodruff Park again, because there was a good 50 to 60, if not more, protesters down here. Everything again was peaceful, but they were trying to get the attention of the Atlanta Police Foundation and Mayor Andre Diggins about dropping this project and telling people again that this is not what they want to see, this future site for this public safety facility. Right now you're seeing more officers, of course. Sorry, Joy, for trying to talk to me. I can't hear anything, but again, you're just seeing some of the remaining officers downtown.
hot, but
They want us to get sound with one of these protesters, and there's like two over there, so let's just go grab them.
okay.
There's not many left hanging out here.
All right, so you have just been watching our coverage of this protest that's underway after the arrest at the future training facility for the Atlanta Police Department. Rachel Aragon, you heard that report from shortly, and she's going to deliver a live report for you later on our newscast starting at 3 p.m., our traditional newscast. Also want to let you know that right now we are keeping our eyes on this courtroom because we are expecting the arraignment to begin at any moment now for nearly 24 people who were arrested. Well, actually, I should say who are facing charges. They're expected to be arraigned on domestic terrorism charges at any moment now. And this follows what is being described as organized attack outside the Atlanta Public Safety Training Facility. So I'm going to show you, these are the individuals who we're looking for in court a short time from now. Police say they're from 15 different states. Actually, only 2 of them charged are from the state of Georgia. These are 23 of these people actually charged, although more than 30 were detained. And it's all stemming from this incident. This is some brand new video that we got this morning showing kind of what happened during these violent protests. Shows the size of the crowd. Atlanta police say it was approximately 100 individuals out here protesting at what protesters call Cop City. And this group would quickly overwhelm police in the area Sunday. At least that is how police describe it. Police say this group was carrying and using fireworks, Molotov cocktails. They were carrying shields while advancing to officers who were patrolling at the scene. Police say people were even attending a nearby event and were caught on camera changing out of their clothes to come over to this new training facility for police and engage in this attack. That's how police describe it. So we're keeping an eye on this courtroom. Many of those protesters expected to face a judge here and be arraigned at any moment. But while addressing the Atlanta City Council on Monday night, the police chief actually said that his officers showed a lot of restraints during this event that I'm showing you, adding that they made lawful arrests. And of course, earlier in the day, opponents of the facility spoke out as well. Let's listen.
Individuals that may use this week to bring further attacks on public safety, on property of this government and private property in Atlanta, Georgia, will be arrested, and they will be placed before a court.
We will not stop fighting injustice, no matter the consequences. Drop all the charges on the protesters. Stop Cop City now. Defund the police. End racist mass incarceration. We are not asking, we are demanding. The people of this city demand this of you. So do it. Do your damn job.
All right. So you heard what the chief said, that people who act in this violent manner are going to be arrested, and they're going to face a judge in court. And that is what we are expecting to happen today. Here's a live look as we watch this feed out of the courthouse, and we wait for these 23 individuals to be arraigned on domestic terrorism charges. Again, only 2 of them are from Georgia. They're from 15 states total. But 23 facing charges out of 100 or so that were protesting in what became sort of an attack, according to police, on the training facility. This is the video. If you're just getting a chance to look at it, it is fairly new video that we just obtained this morning here on Atlanta News First. Yeah, so these 23 individuals are expected to be arraigned at any moment now on domestic terrorism charges. Following the incident that you just saw on video, which happened Sunday night. Here's a live look at the courthouse as we wait for the arraignments to begin for all 23 of those charged. But just for a little bit of context here, this planned law enforcement training facility has certainly been the kind of source of some uproar in the community. But, you know, I should point out that out of these individuals charged, only 2 are from Georgia. But, you know, many people claim it would propagate militarized policing and also harm the environment. And that's why they are holding these protests. And so we do want to point that out. But as I showed you this video, you know, these protests did turn violent. And that's when police say that the protesters were using Molotov cocktails and fireworks and bricks and rocks against them, and also some of the construction equipment. And the construction tractor was set on fire, among some other damage. In all, there were 35 people who were detained, but it's only 23 who are actually facing charges and expected to face a judge any moment now. Again, we're keeping an eye on the courtroom right now. But this site is 85 acres, and that's where this kind of planned new law enforcement training facility will take place at a cost of about $90 million. It's something that you know, many people are taking issue with. some individuals from some faith leaders, just yesterday we brought it to you live here on Atlanta News First Plus, took issue with it for a number of reasons, kind of citing, Native American roots in the land, and apart from harm to the environment, and concerned about militarization via police. And we've seen many activists camp in the forest surrounding this facility as well, and we've been covering that. Remember back in January, officers shot a protester to death at that construction zone during an encounter where a state trooper was also wounded. And many of these protesters are calling for a further investigation into the death of Manuel Terán, also known as Tortuguita. But the Atlanta police chief has said this is not a protest. This is criminal activity, and charges will be brought forth that actually show that. And said in a news conference on Sunday, said, quote, "When you throw commercial grade fireworks, when you throw Molotov cocktails, large rocks, and a number of items at officers, your only intent is to harm." And went on to say that appropriate charges are being coordinated with DeKalb County prosecutors and the Georgia Attorney General's office. No officers were actually hurt in the incident, we should point out. And the chief is emphasizing that officers used non-lethal force to make the arrests. He actually described the accused as violent agitators. He says that his officers used extreme restraint. And, obviously it's something important in light of what happened in January and the death of Manuel Terán. Something that certainly has cast a shadow on police in their handling of these protesters, and has increased scrutiny on how they're handling these protesters as well. Not to mention just kind of this greater context, this nationwide conversation about police use of force and militarization as well. So just kind of keeping an eye here on the courtroom where we are waiting for the arraignment of these 23 individuals on charges of domestic terrorism.
Just give them a deadline, say, look, like 2:30, like I really need to something, I really need this, because I have to have time to put the context of the story.
And something that is worth noting is that the mayor, Andre Dickens, who's a Democrat, has said in the past that he backs the public safety priorities surrounding this public safety training facility. At one point even saying, quote, "The city of Atlanta has the most extensive training requirements in the Southeast, and our training includes vital areas like de-escalation training techniques, mental health, community-oriented policing, crisis intervention, as well as civil rights history education," and saying that training needs space, and that's exactly what this training center is going after. Really, just kind of that's the claim, is that this training center would aim to better educate police. But as you can see, many people don't feel that way. Hence, we're looking at this video from what happened Sunday night. These violent clashes, these protests taking a turn for the worse, becoming violent, involving fireworks and Molotov cocktails and throwing of bricks and setting even a piece of construction equipment on fire. And that's why we're seeing these charges today. It's something that that the police chief has vowed that he would proceed with. Anyone who would go beyond peaceful protests, anyone who would then cross the line into violence would be arrested and charged. It's something that Atlanta police have vowed to do as they try to keep the peace. But it's also something that they've been working to do with restraint, according to the police chief. And it's important to remember, what happened back in January and the killing of a protester at the hands of police in an incident in which a trooper was also injured. That protester, 26 years old, Manuel Tehran. But certainly, the context is important as well. Just these concerns about militarization via police, not to mention the deforestation issue, and like we've heard from some of the faith groups, concerns also about kind of imposition on the Native American history and what some might call territory in this area. And more than 200 acres around this training facility is going to remain green space, is what we've been able to learn. But it's an 85-acre facility, law enforcement facility. I mean, it's huge. It's a $90 million investment. But it's something that police think is going to, that they've stated, is going to allow for better training and more effective policing, and in the long run, kind of provide an opportunity to educate officers on how they can de-escalate and handle incident situations peacefully. But this certainly doesn't look peaceful. This certainly doesn't look peaceful, what we're seeing. And according to police, this was an attack. What we're seeing, this is video from Sunday night. This was an attack on the new training facility, and officers saying that some of them were targeted, and some of the construction equipment was targeted, and one piece of construction equipment was actually set on fire. A tractor was set on fire. You can see that fire in this video. And then you see that smoke there. You see a fire in that piece of video. So if you're just joining us, I mean, this is what we're keeping our eyes on. We're waiting for the arraignment to take place for these folks who are arrested to actually face a judge on domestic terrorism charges. We've got 23 people that will be facing the judge here. So, yeah, we're just waiting for the arraignment to get started for these 23 people on domestic charges, domestic terrorism charges, I should say. They're from 15 different states. Only 2 of them are from the state of Georgia. Okay, I want to now pull up. So it looks like we're seeing some activity on the screen here, but we are hearing that the arraignment is set to begin for these protesters, the ones who, according to police, crossed the line into violence, into domestic terrorism.
believe we're still waiting for the jail to join and bringing all the attorneys in. Looks like we have everyone ready. There's several people in the waiting room who may be witnesses, but I believe there still may be an attorney or so. So if you could give us the name of any attorneys that you know that need to be let in.
Your Honor, Chief Pete Johnston could be let in. I believe he's in the waiting room.
All right. Anyone else that anyone knows of?
One moment, Your Honor. There are several that I sort of expected to see already, so.
Okay.
We have a Kamisha Benz. She may be present in the courtroom. Some of them were actually going to go in person.
Yeah, I'm trying to see what we have. Obviously, a large calendar today, and it was probably not the best one for. And y'all may be seated. Thank you. I appreciate it. And it was obviously maybe not the best one for us to have courtroom conflicts and start late. So appreciate everyone's patience. And my clerk does not have audit. She does not have. She can hear what's going on, but she can't speak. So I will be communicating with her otherwise. So I'll just go through the waiting room as I see it. There is an Apollo Catala.
Your Honor, he's a witness / family friend of one of the defendants.
So what we'll do as far as any witnesses, they're all welcome to watch on the YouTube live stream. If they're testifying in the case, they will remain in the waiting room unless and until they testify, is how we will handle that one at a time. We have Ash Williams. Anybody know Ash Williams? All right. Aubrey. That's, I believe, an alleged victim in a case.
Yes, Your Honor, that's my witness for one of the positions.
And I think we had entries of appearance for James Bass.
It's my understanding that Mr. Bass would be joining us in person from the courtroom there.
Oh, so what attorneys, do we have attorneys in the inmate courtroom? Deputies, can y'all let me know if we have any attorneys there and who they are?
Yes, Your Honor. Yeah, 4.
Okay. And I would expect that all attorneys have filed entries of appearance. If not, they need to get that done today. So who are the 4 attorneys that you have?
Good afternoon, Your Honor. My name is Jennifer Hyman. I'm one of the attorneys here.
Jennifer, what was the last name?
Hyman, Hyman.
All right. Okay. And who are you representing?
I have 3 individuals. Can you hear me, Your Honor?
Yes.
Dimitri Lenny,
Okay.
Atia, and I, Luini, and Grace Martin.
All right. And I may or not, given the size of the calendar, you just may need to remind me as we go down the calendar who represents whom. Okay, who's the other attorneys?
Your Honor, Drago Streetcar. I represent Amin Tawi, Position 6, Position 10, Maggie Deal Gates, Position 11, Priscilla Green, Position 12, Luke Carter, Position 17, Alpha King, Position 18, Zoe Larky, and Position 27, Cameron Pikes.
All right. And again, also, I may need you to remind me as we call the calendar. But I do note that you are here representing people. And I do ask that if y'all have not filed an entry, you need to file one for these parties, okay?
Sure, thank you, Your Honor.
All right. Who's the other attorney we have?
Good morning, Your Honor. My name's James Bass,
Okay.
PA, and I have an associate here with me today,
All right.
Nolly.
Sabrina Hasanawi.
Okay.
That's A-N-A-L-I.
Okay. All right.
Did you want me to get the position 16, Thomas Jerkins?
All right. Go ahead.
Position 26, Alexis Polly.
Frederick Carter.
Oh, you're ready. Oh, sorry. Go.
Yes, Frederick Carter Paul, that's position 30. We have Samuel Ward, position 32.
All right.
Thank you, Your Honor.
All right. Thank y'all. And do we have any other, is that the 4 that are there at the jail?
One more, Your Honor.
Okay.
Good afternoon, Judge.
Good afternoon.
The commission been here on behalf of Mr. Eric Nottingham, position 25 on the calendar. And I do believe that entry was filed with magistrate court maybe about 45 minutes ago.
Okay, well, that may or may not have made it all the way to us. So for anyone who has not filed, please do file that entry of appearance. Otherwise, we're not going to be able to notice you and have you connected to this case in magistrate court, okay? And if there are any preliminary hearings, that's going to need to be there. All right, so we have those attorneys there. I'm not sure who's in, Madam Clerk. If you could let me know if any of these people you've checked in. I'm going to go through the list again. So there's the Apollo Catala. There's the Aubrey, Vonnie Black, Carl Williams, Dami, D-A-M-I. Hold on, let me make it bigger. Gabriel Major, Jay Fuller, Josh Richmond, Julie Clark, J-Y-E-R-E-D.
He's a witness, Your Honor.
Okay. Let's see. Kate Early.
She is a witness as well.
All right, Lisa Wolf. Lyra G. Foster.
That would be an attorney.
All right, let's bring her in and see who she represents. Oops, wrong person. Lisa Wolf may have brought in. And we will formally start the proceedings once we confirm who's here and what they're here for. All right, we have, well, no, now I don't know how this person got brought in. All right, right, Madam Clerk, I'm going to ask you to help me make sure right people get brought in. So Lyra G. Foster should be brought in. Thank you.
Your Honor, I have a witness appearing as well. Do we need to let them in now, or do I let you know when
Just let me, so that's why I've been going down this list. There's a bunch of people in the waiting room who I'm not sure who they are here. Some have been identified as witnesses. If they are a witness, we're going to leave them in the waiting room unless until we get to your case and they're called. Okay?
Thank you, Your Honor.
So you can let me know at that time. So what I think I'll do, since we don't know who's whom, I will let the people in who appear to be attorneys into here. And when you're on a case, if you have a witness, we'll let them out. Let anyone know that they can watch on the YouTube live stream if they are not a witness that is going to be called. All right?
Thank you.
Okay, so Lyra G. Foster, could you please turn on your video? Hello.
Yes, ma'am, that's me.
Okay, are you representing anyone on the calendar today?
Yes, Beeman, Biederman, and Dorsey.
Okay, have you filed an entry in these cases?
Yes, we just got it over maybe a half an hour before the hearing.
Okay. All right. So we are right now trying to sort through people in the waiting room, whether they are attorneys or witnesses. We're going to leave the attorneys here, but I just don't want to leave any attorneys in the waiting room. So I'm going through the list, making sure we do not have any attorneys in the waiting room. So if you know of any attorneys who you do not see on the screen, let me know, okay?
Sure.
All right. And then if you have any witnesses, they will remain in the waiting room until they are called, and then we'll bring them in one by one, okay?
Thank you.
All right, so Lyra G, was that we had her. ML, does anyone know an ML? Mark Bilodeau.
He's a witness, Your Honor.
Okay, Nikita Shepard. Robert Arrington. Stephen Katz.
I believe that is an attorney, Your Honor. I just don't know if he's on any of these.
I agree, so I don't know. So I'm going to bring in Arrington and Katz just to double check. Then the only other one was someone who is labeled XI. So if anyone has witnesses, I will ask that you contact them however you have to let them know to wait in the waiting room. And if they know how, to change their name to make sure their name is reflected so we know who to bring in. All right, Stephen Katz, could you please turn on your camera?
Yes, here I am.
All right, good afternoon. Are you representing anyone on this calendar?
Mr. Biederman.
Okay, so that has two people representing Mr. Biederman? I believe Lyra G. Foster indicated she was representing Mr. Biederman as well. Where did Lyra G. Hold on.
That's all that I had heard so far, but I had not been able to. We had sent someone up there to talk to Biederman, and I was going to ask for a breakout room anyway. So apparently there may have been a miscommunication there.
All right,
I'm sorry, go ahead.
No, I was just going to say, what's your response, Mr.
Well,
Katz?
I spoke with him today, and I spoke with his parents yesterday, today, and my understanding was he had retained me.
Has anybody paid anybody any money to retain them on this case?
Not for me.
Not me either. Not yet.
Okay. All right, well, I'm going to let, y'all are going to have to figure out who's representing him. I know, Ms. Foster, you have a couple of other cases?
Yes, ma'am.
Okay, so I'm going to let y'all, do you have each other's emails?
I don't.
All right.
I can send you that in the chat, I suppose.
Because when we get started, I'll have some general opening announcements that take a minute, and so y'all can try to get everything sorted out during that time. All right, and we can just ask him as well when we get to his case. Mr. Arrington, do you represent anyone on this calendar?
Good afternoon, Judge. No, Your Honor. I was contacted by a member of the National Lawyers Guild who indicated that there might be some individuals who would need representation in light of not having conflict attorneys. So I'm appearing as a potential pro bono counsel for that limited purpose.
Okay, but you're not, as you are right now, retained on anyone on this case?
That's correct.
Right.
I haven't been contacted individually by anyone.
Okay, and so let me ask this of the public defender. For those people who do not have attorneys, with private attorneys who have filed entries, have you spoken with those individuals?
Judge, I was made aware prior to today's court hearing that all of the people who were charged with domestic terrorism were being represented by outside counsel and did not need public defenders, so I have not spoken to any of them.
Who made you aware of that and how?
Attorney Bass and I discussed yesterday. He was setting up with other attorneys, some of them present here today, who was going to be represented by who. So I had a list of them assigned to each person that was arrested during that altercation. So I did not speak to any of them. And neither did Ms. Arnice.
Okay, well, what we will do, Mr. Arrington, is leave you in, we'll just leave the attorneys here, all right? If we get to anyone, because there are so many people and so many different attorneys, if we get to someone who is not represented, we will address it at that time, all right? But normally the process obviously is that a defendant is retained and an entry of appearance is filed. So it could result in some persons needing to be reset till tomorrow if you have not had a chance to speak with them. And I'm just letting you know.
I understand, Judge. Would it be possible if those individuals do come up to be put into a breakout room with them?
Well, it would, but you see how the jail is right now?
I do.
And so that's not really conducive to, we'll see what we do when we get there. All right.
And I'm here for the efficiency of the process. There are also 2 other attorneys I've been working with who are available for the same purpose. I'm not sure if they're still in the waiting room or not.
All right. So what I may do is leave you here because I don't want to have too many people on the screen at one time. What are there? And obviously, like we've told everyone, the people who are not witnesses and who are not attorneys, they're all welcome to watch via the YouTube live stream once we get that up and going, if it's not up already. But we want to get everyone checked in and make sure everyone's audio and video is working first.
Sure.
Who are the attorneys that work with you?
The other attorney is Lisa Wolf.
Lisa Wolf. Okay, she is in there. So given the numbers, I'm not going to, there may be some people in the waiting room who are not witnesses and got this Zoom link from someone and are just hanging out there. If there anyone that you know as a witness, I again ask that you let them know that they will remain there until they're called in. And anyone else who is there is free to watch on YouTube, but not to come into this part of the session because we want this to be as efficient as possible. All right, so.
Ms. Davis?
Yes.
Put a number in the chat for the cell phone in case they need to speak to someone.
Okay, I appreciate that. So attorneys, there is a phone number in the chat of a cell phone that if you need to speak to someone, don't go ahead and call it. You have to let me know first so the jail knows to expect it. And then we will let you call that number to speak with someone, okay? All right. So we can go ahead and go live. Madam Clerk, you have not had any notification of anyone trying to join the Zoom calendar who is unable to, is that right? Oh, and I have to wait for her to give me a notice. So we will go ahead and go live at this point. All right. This is the March 7th of 2023 Magistrate Court of DeKalb County Felony First Appearance Hearing Calendar, meaning everyone on today's calendar has a felony attached to their case. I'm Judge Davis. I'm sitting for this calendar and will be presiding this afternoon for DeKalb County Magistrate Court. First, everyone needs to understand that to ensure that the public has access to our courts, this hearing is being broadcast on the DeKalb County Magistrate Court YouTube live stream channel. At the conclusion of the entire calendar, the video will be removed from the court's YouTube channel and no longer available for viewing. But be aware that anything you say is being live streamed, but also being recorded by DeKalb County Magistrate Court and can be used against you later in your criminal case. Other than the court, however, pursuant to OCGA 15-1-10.1, No one has the authority to record these proceedings without having given prior notice and receiving prior approval from the court. There have been some likely journalist requests that are set up where they may be having gotten approval, but anyone else, if you have not received approval from the court, participants or viewers out on the World Wide Web, if anyone has a device currently recording, you are ordered to stop recording now. The strict prohibition on recording applies to any video recording, but also screenshots and photographs. Any unauthorized recording is not official, shall not serve as a transcript for appeal purposes, and can result in criminal contempt consequences with the possibility of incarceration for anyone involved in the unauthorized recording of these court proceedings. Now, for those who are on this calendar, this is your first appearance hearing, and it is not the trial of your case. It's what we call a non-evidentiary informational hearing to make sure you understand what you are charged with, to advise you of your rights in a criminal proceeding, and to consider and set bond in your case if I have the authority to do so. I'm not here to take any pleas or determine anyone's guilt or innocence, so we're not really here to discuss the facts of your case at length in either direction. Please understand that not only is this calendar being broadcast over the internet, but as it is being recorded, anything you say will be used against you likely in any later court proceedings. In some of your cases, I cannot set bond by law, or I might deny bond, but that doesn't mean that you can't ever get a bond. It just means you will not get one today from this court. Your attorney will follow up with you about filing for a motion for bond to be heard in Superior Court, and your case will be set down to be scheduled for a preliminary hearing in the meantime. Now I'm going to inform you of the rights you have in any criminal case. You have the presumption of innocence unless and until the state proves the charges against you beyond a reasonable doubt at trial, or until you enter a guilty plea. You have the right to a jury or a bench trial, and at that trial, the state has the burden of proving every element of every charge against you beyond a reasonable doubt. You have the right to confront the state's case, to cross-examine their witnesses. You have the right to call your own witnesses at trial, and to introduce your own evidence. You have the right to use the subpoena power of the court to compel witnesses and evidence into court. You have the right to testify at trial, but it can be used against you, and you would be cross-examined by the state, and that testimony would likely be used against you at trial. On the other hand, you have the right to remain silent, and that silence will not be held against you, and you have the right to be represented by an attorney. If you cannot afford an attorney, one will be appointed to represent you free of charge. Everyone today generally has had time to speak with a lawyer from the Public Defender's Office unless the Public Defender's Office was notified otherwise. If you have a private attorney, you need to let me know that today while we call your case. You have the right to what is known as a probable cause or a preliminary hearing, which is the next hearing you may have. A preliminary hearing is a hearing in front of a judge to determine if there's enough evidence or probable cause to support the charges against you. Not whether you're guilty or innocent, just if there was enough to arrest and continue to hold you on those charges, whether those charges be changed or dismissed. The state will present evidence, and you and your attorney will have an opportunity to examine this evidence, and if after this hearing the judge finds there's enough evidence to support the charges you are arrested for, your case will be bound over to the Superior Court, where the district attorney may further investigate and formally charge your case. Please note, even if your case is dismissed at the preliminary hearing stage, the state may still go forward and formally present evidence and formally charge your case. Also, once the state has filed formal charges against you, you no longer have the right to a preliminary hearing. When you get out of jail on bond, you generally waive your right to have a preliminary hearing unless there are significant restrictions attached to your liberty, or restrictions to your liberty attached to your bond. If you are released on bond on your felony charge, you would need to file a motion for a preliminary hearing, and then you and your attorney would receive notice of that preliminary hearing. So we'll ask and find out today if you want to have your case scheduled for. You no longer have the right to a preliminary hearing. When you get out of jail on bond, you generally waive your right to have a preliminary hearing unless there are significant restrictions attached to your liberty, or restrictions to your liberty attached to your bond. If you are released on bond on your felony charge, you would need to file a motion for a preliminary hearing, and then you and your attorney would receive notice of that preliminary hearing. So we'll ask and find out today if you want to have your case scheduled for a probable cause hearing or if you want to waive it. If you get out of jail on bond, you still have the right to be formally charged via accusation and indictment, and you have the right to the trial by jury. Once you have been formally charged in your case, you will have an arraignment date before a Superior Court judge where you can enter a plea of guilty and be sentenced, or enter a plea of not guilty and have a jury trial date set in your case. If you are convicted via plea or trial of any felony offense, you may face a minimum of 1 year up to a maximum of life in prison, depending on the severity of your charge and other factors. Some or all of that may be served on probation, again, depending on the charges. If you are convicted at trial, you also have the right to appeal that conviction. Now, to set bond and to determine a reasonable bond for your specific situation, I will hear from your attorney in the state and be looking at the specific charges and circumstances surrounding your arrest, your criminal arrest and conviction history or lack thereof, which I have received for everyone on this calendar and the attorneys may reference at times, any risk factors or lack thereof concerning bond and your financial situation. Examples of risk factors are whether there's a significant risk that you won't return to this jurisdiction or flee the jurisdiction while you're out on bond. Is there a risk that you might be a threat to danger to people, property, or the community while you're out on bond? Is there a risk you might commit a felony while you're out on bond? And is there a risk you might intimidate witnesses or victims or otherwise obstruct justice while you're out on bond? Along with posting a bond to get out of jail, some of you may be asked to sign a special condition order, acknowledging any special conditions attached to your release on bond. So I'm going to give you a few examples of the ones we see most often, because it's very important to understand your condition if one is attached to your bond. A common one is a stay away or a no contact special condition. If you are given a special condition that requires you stay away from someone, then you must stay away and have absolutely no direct contact or indirect contact by person, telephone, social media, any other means of communication with that person and their home, job, and school. You can't be near them even if that person says you can, because it would still be a violation of your bond condition. Complying with the stay away order helps protect you from future allegations and helps the other party feel safer while the case is pending. If you violate that special condition, your bond can be revoked and you may be arrested again and possibly face additional felony criminal charges that would only be bondable before a superior court judge. If you are given a no contact condition and you're living together, you may also be given one trip to be arranged in advance with law enforcement via their non-emergency phone number to have them escort you to get any necessary belongings, such as clothing, medication, necessary items, not furniture or the flat screen TV or items that require moving, because this is just temporary while your case is pending. Another type of special condition is that you have no violent contact with the other person, which generally means you may still be around them, but you can't engage in any conduct with that person that might be considered violent, such as yelling, pushing, shoving, throwing things around, and breaking stuff, some of which is already a crime anyway. If you engage in that kind of conduct, that conduct alone is enough to violate your bond, and your bond may be revoked, and you may possibly face additional charges. In other cases, you may just be asked to not return to a location. So if there is a special condition attached to your bond, you'll be required to sign that special condition via an electronic signature pad the deputy will hand you. You will get a copy of that special condition either today or by the time that you bond out. And during the pendency of your case, that special condition is in place unless and until a judge orders anything different. If you make bond or are released on any charges otherwise, be sure to keep your address updated with the appropriate court clerk and know the location and telephone number of the public defender's office or your other attorney to be sure you will get notice of future court dates. Now, when I call the calendar, I'll call your name once I get your information pulled up in my computer. I have a couple of computer screens going here, so I may be looking down or sideways at different times, but I'm still working, I promise. It may take a minute to go through for the system to pull up and refresh as we go through each charge. So I ask in advance for you to be patient with us on that. Once you are standing, I'm going to read the case, the warrant numbers, and the charges, and make sure you've had a chance to go over the charges with your attorney, that you understand what you are being charged with, and your attorney may waive a formal reading of your charges. Then I will hear from you and your attorney and the prosecuting attorney on bond. Since you are represented by an attorney today, you shouldn't be asked many questions, but if you need to answer any questions, please answer towards the microphone that the deputies have pointed out to you. I generally call the Superior Court only cases first, which are cases where the charges are ones that statutorily the bond can only be heard in Superior Court. So that means I don't have the authority to even consider bond today. That means your attorney will be filing a motion in Superior Court where your case will be set down for a hearing, generally within a few weeks. In the meantime, your case will be scheduled for a probable cause hearing. So we have a large group with us today. Generally, I need to go ahead and move the Superior Court only cases so I can get some people out of the courtroom. I am open to any recommendations. Otherwise, after that, deputies, do y'all have any specific person you need me to take first?
No, Your Honor.
Okay. All right.
Can I volunteer somebody?
Wait, who?
Thomas Jurgen, physician.
So no, that's not how we're going to work it, because I need to move people faster. And so what I'm going to do first is get the Superior Court only cases out of the courtroom. Then I will do a consent. And then if these other parties are all co-defendants on same cases with the same allegations, I will hear on how people I will hear from the state and defense counsel on how they would prefer I proceed at that point. Okay, so I will take the private attorneys first. But doesn't hurt to ask. But let me go ahead and take the Superior Court only cases first so I can move some of the bodies out of the courtroom. All right, because I know it's crowded in there for y'all. So the Superior Court only cases I have, the first one I have is position 13. That is Mr. Nathan Earl Henry.
That's our niece, Cabrera Alvarez, on behalf of Mr. Henry, Your Honor.
All right. Good afternoon, Mr. Henry. You are charged in case number 23-019620 with 1 count of aggravated assault, family violence. The warrant number is 23W003547. Your attorney indicates that, or Ms. Cabrera Alvarez, I'll need to ask you, have you had a chance or someone from your office had a chance to go over the warrants with him?
Yes, Your Honor, and that can be a standing waiver of reading of the warrants.
All right, thank you. All right, so Mr. Henry, your attorney indicates that someone from their office has had a chance to go over the charges with you, and they're waiving a formal reading of the charges into the record. Do you understand the charge against you, sir?
Yes.
All right, thank you. Okay. This charge is your charge can only be heard for bond before a superior court judge because of your prior felony convictions, including a couple of burglaries. So we cannot address bond in your case at this time. What we will do is your attorneys will be filing a motion for bond to be heard in superior court. And in the meantime, we will schedule your case for a preliminary hearing. Okay, sir? All right, thank you. And you can follow the direction of the deputies. All right, next I have case number 23-019516, Bruce Andre Hines.
Hines, come on up. Corey Henders for Mr. Hines, and I would waive reading for him and all of my clients today, except for position 9, that we need a specific language interpreter for.
Yes, and I haven't gotten an answer on that one yet, so we will see where we are when we get there.
Thank you.
All right, Mr. Hines, good afternoon. You were charged in case number 23-019516 with rape and aggravated sodomy, and warrant numbers 23W003557 and 58. Your attorney indicates that someone from their office has had a chance to go over the charges with you and is waiving a formal reading of those charges into the record. Do you understand the charges against you, sir?
Yes.
All right, thank you. So your charges are only bondable before a superior court judge. So your attorneys will be filing a motion for that to be heard in superior court. And in the meantime, we will set your case down for a preliminary hearing, okay?
Yes.
All right, thank you, sir. That's all we can do for you today. So please follow the direction of the deputies. Okay, number 33 is 23-10941, Darius Demond Elliott.
It's our niece, Cabrera Alvarez, on behalf of Mr. Elliott.
Thank you. Good afternoon, sir. You are charged in case number 23-109481 with distracted driving, failure to signal, and trafficking and illegal drugs violation of the Georgia Controlled Substances Act. Your attorney indicates they've had a chance to go over the charges with you and are waiving a formal reading of those charges into the record. Do you understand the charges against you, sir? All right, thank you. Your case is only bondable before a superior court judge. So your attorney will be filing a motion before superior court for you to be heard on that. And in the meantime, we will schedule your case for a preliminary hearing, okay? All right, thank you, sir. Please follow the direction of the deputies. Number 34 is case number 23-01096A, Miracle Neve Williams, charged with armed robbery, terroristic threats, possession of a firearm during the commission of a felony, and warrant numbers 23W003529-31. Good afternoon, ma'am. Your attorney indicates that she has had a chance to go over the charges with you and is waiving a formal reading of those charges into the record. Do you understand the charges against you, ma'am?
Yes.
Thank you. And again, for everyone who's listening, understanding the charges does not mean you agree with them. You just understand what someone else is alleging against you. Okay. So, ma'am, your charge is also only bondable before Superior Court judge. So your attorney will be filing a motion to be heard in Superior Court on your bond. And in the meantime, we will schedule you for a preliminary hearing, okay?
Okay.
All right, thank you, ma'am. You may follow the direction of the deputies. Okay. So normally we would take all the ladies first, although we have a big mix of ladies and several co-defendant cases. So at this time, I will hear, we have several private attorneys, and Mr. Johnson, what cases are you here on?
Good afternoon, Judge. I'm here on all of the domestic terrorism cases, so we're here at the court's leisure, however you want to take it.
All right, well, I think I'm just going to start at and is it correct? Go ahead.
Oh, and I was just going to say, Judge, based on one of the things you were announcing a moment ago, I will say that one defendant, we do have a consent bond to. I can tell you the position. Let's see. Position number 16, Thomas Jurgens. But other than that, the rest will all, we'll go through the normal process.
Okay.
And Judge, if I may, I know we typically do take private attorneys first. However, the public defender's office only has about 5 other cases on today's calendar. I don't know if you want to move those a bit quickly. I think some of them are consents as well. I just wanted to point that out in case you wanted to get more people out of the.
I understand. I also understand that some defendants might end up having to talk to some parties at some point. And I'll tell you the only reason I'm hesitating on the consent is because all of are going, doesn't mean I'm not going to grant it, but if all of the individuals before me are all charged with the same thing, essentially, it would be good to hear what others are charged with versus what this person is charged with and why there's a consent for him and not others. Does that make sense? Mm-hmm. So let's see. So the consents you have, I just had one for the public defender's office.
Your Honor, there was one that is English speaking. The other one is a Spanish language line UJR consent.
Okay. So yeah, we're going to have to, but this is what I will tell the public defender attorneys. If while we're taking up the other cases, if y'all want to turn off your cameras, you are free to, as we get to your cases. I think the most organized fashion to handle this may just be going down the calendar, to make sure we get everybody as we go. Okay. So, since we have so many co-defendants and so many private attorneys, I'm just going to go down the calendar starting at the top. So the first person I have is, and this is the co-defendant case. So the co-defendants are under case number 10-0277-25-22, positions 1 through 4, 6, 8 through 12, 16 through 22, 24 through 27, 29, and 32. And we have various private attorneys representing, or reportedly representing defendants in this case. So the first case I have is Jack April Beeman. And that is you, Ms. Foster, correct?
Yes, Your Honor. By the time that we got there to interview Ms. Beeman, she was already being moved. So I still need to speak with her. If at all possible, I'd like to avoid being reset if there's any way to do a breakout room or separate call.
All right, so you will be the first breakout room. Deputies, may Ms. Beeman speak with Ms. Foster, and Ms. Beeman, you may call that number. That number's in the chat.
So I call that number?
Yes, you call that number and you turn off your audio and video here. Call that number in the chat and they will allow you to speak with your client.
Okay, fantastic. Thank you.
Okay. All right. The next one, Mr. Katz, Ms. Foster, did we get a resolution on Biederman? Who's representing Biederman, since both of y'all said you represent her? Him, I'm sorry.
I think, Your Honor, we need to speak with Mr. Biederman if we could in a breakout room.
Okay. And so public defenders on your other cases who are out there, I may end up hearing your cases while they're speaking to their, depending on how things work out. So Mr. Katz, you're going to have to call the number that Ms. Foster calls after Ms. Foster is done talking with her first client, Ms. Beeman. Okay.
Okay.
So we'll let you do that next.
So I'll just let, oh, sorry.
Go ahead.
I'll when I get back on, I'll let you know that I'm here so that we can do that second call, I guess.
Okay, that's fine. Thank you.
Okay, thanks.
All right, position 310 is the same case number, warrant number 23W003593, Timothy E. Bilodeau.
And that's my case, Your Honor, Amanda Clark Palmer.
All right, thank you. Ms. Palmer, have you had a chance to go over the charges with your client?
So I have not talked to him. I believe he knows that he's charged with 1 count of domestic terrorism. If we could confirm that.
Okay, that is the count. Let me pull him up briefly. Do you, and it sometimes is easy for me to do all under the same case in the system because once it's pulled up, I can pull up each person separately rather than go back in, but hold on. All right. So normally, so the public defender's office has not had a chance to go over the warrants with anyone under this case because they indicated they were informed that all the parties in this case would have private counsel.
I think another lawyer, not a public defender, may have gone over the charges with Mr. Bilodeau.
Got it. Okay. So do you want to ask him if anyone has gone over the warrant with him?
Yes, I'd like to ask him that.
Okay, go ahead.
Mr. Bilodeau, my name's Amanda Clark Palmer. I'm your lawyer at this hearing. Have you been told what the charge is against you and shared the nature of the allegations?
I have.
He has.
Okay.
And we'll waive reading of any charges.
Okay, that was my next question. All right. So, sir, you were charged with 1 count of domestic terrorism in that warrant. Your attorney indicates someone has gone over the charges with you and is waiving a formal reading of those charges. So do you understand that charge against you, sir?
I do, Your Honor.
All right, thank you. At this point, I do not have a criminal history listed or was not provided with a criminal history from Mr. Biederman, and I will hear from the state on bond.
Yes, Judge, and that's correct. We're showing as well no criminal history for Mr. Bilodeau. What we do know is that he is from Massachusetts. He's from out of state. It shows, at least from what we can see, that he has no ties to Georgia, and that, you know, he was arrested for domestic terrorism from an incident from March 5th, and we would oppose bond because we believe that he is a threat to reoffend if released. However, we understand that if the court does grant a bond, normally we would argue that because he's out of state, he could be a flight risk. What I would request, and what we've done, because this is now going to be the third kind of group of defendants that have been charged with domestic terrorism coming before a first appearance or a bond hearing, is that part of the bond conditions, if this defendant is granted a bond, would be that he go back home, essentially, to Massachusetts and stay there and not come back to Georgia unless and until for required court hearings otherwise, and obviously to stay away from the location where this happened. So that's the state's position, Your Honor.
All right, Ms. Palmer.
Thank you, Your Honor. First, I'd like to note that in the warrant specifically, there's a lot of generic language about what the whole group of people is alleged to have done. But when it comes down to the allegation against Mr. Bilodeau specifically, it says the accused was observed with muddy clothing from breaching and crossing the embankment. Accused was also in possession of a shield. So there's no allegation that he was personally observed throwing a rock or a firework or anything like that. It's more akin to a criminal trespass allegation. It is correct that he is from Massachusetts. I've got both of his parents on the line who can testify to the court, as well as 2 or 3 character witnesses who are here and ready to testify as well. He is 25 years old. He has a degree in mechanical engineering and a minor in music from Northeastern University. He's currently employed at a technology consulting firm where he does research and data analysis for the firm. Before that, he was a school teacher and he taught math and engineering to students. He lives in an apartment in Cambridge, Massachusetts with 3 other people. That's 10 minutes away from his parents. So he's in close contact and communication with them. They have a very close relationship. He also has a very close relationship to his grandparents who are in their 90s, and he regularly goes over and prepares meals for them and makes sure that their needs are taken care of. So he's got, although he doesn't have ties to Georgia, he's got significant family ties that would keep him from absconding and not reporting back for court. He also has, and I'm sorry, his parents are both employed. They have stable jobs. They are prepared to marshal their resources and post a bond for him, which would also be a significant condition that would make sure that he complies with any conditions the court sets for him and that he returns to court as necessary. I have, as I said, 3 character letters from people who have known him. Or I'm sorry, I have 2 character letters, and then there's one other witness who is here. And so I'll briefly summarize the character letters. One is from his former calculus teacher, who he still maintains a friendship with. And the teacher says that the teacher's name is John, and I'm going to mess up his last name, Yered. He's one of the people who's on the Zoom and is here to testify. He says that he became acquainted with Tim quite well, and they kept in touch after graduating high school. Tim was a model student and member of our school community who always followed classroom rules and procedures. He's polite and treats others with respect. He generously volunteered his time to tutor younger high school students who were struggling in math. He's always seemed genuinely interested in helping people. It says a lot more, but I'm, in the interest of time, summarizing. He concludes by saying, in short, during all of the interactions I had with Tim, I saw a respectful, kind, and generous young man. Then there's another former teacher, his former violin teacher, who says that, and her name is Bonnie Black. She was his teacher. And then Tim became her teaching assistant, then became a colleague and is currently a dear friend. She says throughout the 10 years she has known Tim, she finds him to be one of the most principled, upstanding, responsible, and trustworthy people I have ever known. He is a passionate young man of impeccable character and is held in high esteem throughout our community. He's passionate about community service and spends countless hours on evenings and weekends volunteering his time to help better the lives of those around him. He volunteers every week to teach computer coding and engineering to inner city youngsters at the clubhouse. He pours his entire heart and soul into helping those less fortunate than him and is doing life-changing work every day. She shares a story about a time when she broke her foot, and Tim continued for many months to help her with everything from grocery shopping to dog walking. She says he is a valuable and rare person with so much goodness it can scarcely be described in a short statement. He lives a principled life in service to others and is an inspiration to all around him, and she has an enormity of respect for him. And so, Your Honor, as I said, his parents are on the line. They're here if you need to hear from him, but what I am asking the court to do is to set him a $10,000 bond, because I understand that's consistent with what has been set in these types of cases in the past. Of course, he will agree not to come back to the state and any other conditions you want to impose. And if you want to hear from his parents, we can bring them in, but I know it's a large calendar, and if you're inclined to set a bond, we don't.
Well, I'll let you, I wouldn't base my decision on whether or not I'm inclined to set a bond, but I accept the fact that there's this good character evidence that has been submitted, that his parents will testify similarly, and will do what they want to do per any conditions and bond. That would be, I mean, I'll accept that.
And they would volunteer as like a, a custodian or surety if the court wanted them to kind of sign on to the bond conditions as being people who would make sure that he's compliant with whatever he needs to do.
Okay. All right. Anything else, Mr. Johnston?
Your Honor, just the only thing, I didn't go deeply into the facts because I heard what the court said earlier about, what the purpose of today is, but I did hear Ms. Palmer say something, so I just wanted to address that.
And let me say something on the fact, I mean, yeah, I can't go into whether someone's guilty or innocent, but the totality of the circumstances and the circumstances surrounding the arrest are relevant of what I based my decision on, simply because that's what determines whether something's a misdemeanor, a felony, or a superior court only case, right? The facts that are before the court. And so I do take that into consideration, the seriousness of the offense and allegations. But go ahead.
Right, of course, Judge. And all I was going to say was there was a statement made that this was more akin to a criminal trespass. The state would disagree with that. In this particular case, just to give you kind of the thumbnail of, and this applies to all of the defendants on the calendar today, is there was a concert that was planned illegally because it's on private property that or lands that you have to get a permit to have a concert on, which none were obtained. But that's fine. That's kind of here. A group marched from that concert to another location that was quite a distance away. It wasn't just like you step a few feet and you're there. You had to make a concerted effort to go there. This group changed their clothing into all blackout clothing, basically. They had shields that were like riot type shields, homemade shields. They had bags of rocks. They had fireworks. They had Molotov cocktails. This was a group that broke off from the concert group and then went. That is who Mr. Bilodeau is. And he was one of those who was in possession of a shield. So he wasn't just trespassing. I just wanted to make that clear for the court.
Well, and that's not what he's charged with at this time. So that's what I'm considering the charges before the court.
But Mr. Johnson, I did read the warrant correctly, right? Which it doesn't make any mention that he personally was found in possession of fireworks or rocks or anything.
So let me, I'm not going to go back and forth about, so let me just say about the offenses before the court are that all the parties were involved via association in this action, right? And the actions reference things that could be considered aggravated assault on law enforcement officers and arson. And they are all alleged to have been party to this whole same association for marching over there armed and doing these things. So while I do not have aggravated assault upon law enforcement officer in front of me, I do have that as part of the circumstances surrounding these charges. And I do take that very seriously. And this does put this in a little bit different position than the other groups that have come through the court. So I will consider each one on its own, but I will also consider very strongly the allegations in front of me. And I'd note also that this is not a statutory superior court only offense, but a similarly situated street gang and terrorism is statutorily superior court only offense, and it has a lesser punishment range, sentence range than domestic terrorism. So I also have to look at the seriousness of the offense and what time this person may be facing as a possible sentence down the road. So these are all things I'm balancing in addition to lack of criminal history or ties to other, communities and character and things like that. So anything else, Ms. Palmer?
Yeah, Your Honor, I'd like to present the, I would just like his parents to come on and verify that they'll be, his custodians or surety. And then I'd like the court to briefly hear from that third character witness for whom I don't have a letter.
Okay, I will briefly hear from all of them, noting that I expect them to say what you said, have proffered. All right, so who's the first person you would like to bring in?
Kate Early is his mother.
Madam Clerk, I may need you to help me if I don't. Okay, she's joining.
Hearing. Miss Early, if you can hear us, can you unmute and turn on your camera? And I'll text her. I think she's on. There you go. All right. Your Honor, do you want me to swear her in?
Yes, please.
Okay, Miss Early, will you raise your right hand? Do you swear or affirm that the testimony you're going to give to the court in this matter will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do swear, yes.
Okay. And are you Timothy Bilodeau's mother?
Yes.
And where do you reside?
In Watertown, Massachusetts.
Okay. How far away do you live from your son's apartment?
About 10 minutes.
Okay. How often do you see him? I mean, do you see him on a daily, weekly basis, something like that?
Probably a weekly basis normally, but we do, yeah.
How often do you talk to him via text or phone call?
Yes, daily.
Daily. Okay. Did you send me an email earlier today kind of summarizing Tim's background and some information about his grandparents and your job and things like that?
Yes, I did.
Okay. And I've shared that with the court already. Can you confirm to the court that if Tim is granted a bond, that you will ensure to the best of your ability that you abide by any bond conditions that the judge assigns to him?
Absolutely.
Okay. And are you and your husband willing to post a bond for your son?
Yes, we are.
Okay. Do you believe that if your son is granted a bond, he will come back to court when he's supposed to?
Absolutely.
Okay. Will you do your best to make sure that he gets back to court when he needs to be here?
I will accompany him myself.
Okay. Do you believe that he's a risk to commit a crime if he's going to be granted a bond?
Not at all.
Do you think he would be a danger to anybody if he was granted a bond?
Not at all.
Okay. Or to any property or to the community as a whole?
No, no.
Are you willing to sign on to his bond as a custodian if the judge asks you to do that?
Yes, absolutely.
Okay.
We
All
definitely plan to go down and, bring the bail and then bring him home immediately.
Okay. And I know your husband is not with you, but is he also on this Zoom call?
Yes, he is.
Okay. And do you think that he would agree with everything that you've told the court this afternoon?
Yes, 100%. Yes.
All right, Your Honor, I don't have any more questions.
Mr. Johnson, do you have any questions for this witness?
No, Your Honor.
Okay. Thank you, ma'am. You may be excused.
And then, Your Honor, the other person would be Apollo Catala.
Oh, that is your person. Okay. I had asked about them earlier. All right.
And Mr. Catala, if you can hear us, could you unmute and turn on your camera, please? We'll try texting him as well, Your Honor.
All right, sorry about that.
Okay. There you are. Okay.
I am just going to step into the conference room so that I could have some privacy. Just take me a couple of seconds.
Okay.
Okay.
Sir, my name is Amanda Clark Palmer, and I am Timothy's lawyer. And I need to swear you in so I can ask you some questions before the judge, okay? Sir, do you swear or affirm that the testimony you're going to give to the court this afternoon will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay. Sir, where do you reside?
I live in Dorchester, which is part of Boston, Massachusetts,
Okay.
specifically at 45 Mascot Street.
Do you know Timothy Bilodeau?
Yes, I do.
How long have you known him?
I've known him for several years, more than 3 years at least, maybe more. I just don't have a good count on my head this morning or this afternoon.
And sir, how is it that you know Timothy? What does he do with you?
Timothy has been a volunteer at a urban farm that I run in Dorchester, in the Dorchester part of Boston. And he has been coming over the years on Thursdays, Saturdays, and sometimes on other days. I also know Tim from volunteering with him at a farm outside of the city of Boston, a farm that many of us like to go to. It's a bigger farm, and we do all kinds of things like growing stuff, obviously, but infrastructure, we build things, and Tim has been very instrumental in that. He's helped out with building a tiny house. He's helped out with our high tunnel and putting up the infrastructure to allow us to grow the year round. These are pretty significant things for us, and that's the kind of work that he's been involved with us. He's also a pretty good grower of garlic and other varieties of crops.
Okay. And sir, in that time, do you feel like you've gotten to know him and formed an opinion of his character?
I do, and what I didn't put on there is that when Tim is not volunteering at Baloo, he is volunteering in other parts of the city with young people in BIPOC communities in particular and beyond, but he's also been doing that. I think the world of Tim. He is not only a good carpenter, a good farmer, gardener, he's also an excellent human being in all the interactions that I have had with him. I've been over to where he lives. I've gone out, I've done social gatherings with Tim, and he's always strikes me as a stand-up, first-class human being.
And so, sir, if he was granted a bond, do you think that he would be a risk to commit a crime while out on bond?
Absolutely not.
Do you think he would be a danger to any person if he was granted a bond?
Absolutely not.
Do you think he'd be a danger to your community or to property in the community?
Absolutely not.
And do you think he would come back to court when he's supposed to?
I believe absolutely that he would.
Okay. Those are all my questions, Judge. Thank you.
All right. Any questions, Mr. Johnson?
No, Your Honor.
All right. Thank you, sir. You may be excused.
Okay, thank you.
Any other witnesses?
I'm not going to call any other witnesses, Your Honor, but you know that there are other people who are here that could testify, but I don't want to call them.
Okay. Anything else, Mr. Johnson?
No, Your Honor.
Okay. The lack of criminal history and good character is part of the equation. But based on the allegations before the court at this time, I'm going to deny bond and find there's a significant risk of danger to persons and property in this community at this stage of the case. And there is a lack of ties to this community. So a risk of not returning to the court. Any issues with evidence, y'all are welcome to file a bond motion before Superior Court and have your motion heard there. And in the meantime, we will set the case down for a preliminary hearing. Okay?
Thank you, Your Honor.
All right. Thank you, Ms. Palmer.
Mr. Bilodeau, I will come speak to you as soon as I can.
All right, sir. So just follow the direction of the deputy, please.
May I be excused?
You may. Was that your only case?
Yes.
Okay. Thank you, ma'am.
Thank you.
All right. Next, we have Emma Bogush. I apologize if I mispronounced your name.
Good afternoon, Your Honor. This is Eli Bennett reporting on behalf of Emma Bogush.
Thank you. This is case number 10-0277-25-22. Warrant number 23W003592. Have you had a chance to go over the warrants with her in this case?
I received the warrants somewhat earlier this afternoon. My client is aware that she's being charged with 1 count of domestic terrorism, and I'm authorized to waive reading of those warrants at this time. I'll review them with them at a later date.
All right. Okay. So, ma'am, your attorney indicates that he has gone over what you're charged with initially and is waiving a formal reading of the charges with you. Do you understand the charge against you, ma'am? Yes. Okay, thank you. All right. I will hear from the state on bond in this case.
Yes, Your Honor. The defendant is from Bethany, Connecticut. Again, kind of like the last defendant, has what appears to be no ties to this community. And the facts are the same based on the warrant, and the evidence that we have right now is that there was a group attending a concert and then a group that moved to a separate area to, as you've already heard me say, I won't belabor it. What's significant about this defendant, like the last one, also is that in addition to the allegations of the party to a crime on the domestic terrorism with the ag assault and arson, is the fact that this defendant was also in possession of a shield as well. And so for those reasons, Your Honor, we believe that this defendant is a threat to the community and a flight risk and would oppose bond.
All right, thank you. Mr. Bennett?
If I may, Your Honor, just a few factual clarifications before I get into the information that would be relevant to the Ayala factors. Firstly, Your Honor, the warrant alleges that 44 people were detained in connection with this event on Sunday. 11 subjects were determined to have not participated in violence or acts of destruction, were not muddy, and had legitimate reasons for being in the area. We are aware, or I am aware, of only 23 detainees currently charged with domestic terrorism. So I guess this is more of a question for the state. Are there an additional 10 detainees? Or
no, some of those individuals were either released or they were charged simply with criminal trespass. They were not charged with domestic terrorism.
Understood. Thank you for that clarification. The second factual clarification that I think the court should be aware of in this case is something that we've determined, or I've determined from interviews with various individuals at this stage, that there were really 2 events taking place at various times, not necessarily concurrent with each other. There were about 1,000 attendees at the music festival. It was a concert. There were artists there. There were local musicians there. There was a itinerary of events that were mostly related to forest ecology, art, music, expression, political expression, and artistic expression. There were over 1,000 people present. And this location where this took place was quite some distance away on public property. Granted, permit was probably required. That's a misdemeanor citation for the organizers, I would expect. There was another area that was a significant distance away, and the warrant even says, you know, had to go pretty far or something kind of vague, but that's true. There were approximately 50 to 100 people who participated in what looked like, you know, essentially a riot, and they were dressed in black. I've seen the video. It's been played all over the local news. So that's a separate event. The arrests of each of the clients that I'm representing today, but likely the other clients, likely the other individuals as well, was at least an hour after these alleged, I won't say alleged, there were fires, after these fires were set and property was damaged, okay? So what we're not going to see in this case, and what we haven't seen against any of these defendants, is a charge for arson, is a charge for interference with government property, which carries a potential 20-year sentence, as does arson, is you know, any kind of felony criminal damage. I believe one of the tractors that burned up was six-figure value. None of these defendants are charged with that. And the reason for that is because the state has no evidence, no direct evidence, as Ms. Clark Palmer alluded to, that any of these individuals actually committed acts of violence. The evidence, at least as alleged in the warrant, is they were muddy and they had shields. And the shields is the first I've heard of this. I suppose there's going to be police reports or body cams or videos. None of my clients have mentioned anything about the shield. Okay, and that language is identical in each of these warrants. So frankly, I don't trust these warrants or their factual accuracy. I think they are, but they are, and a judge has signed them. I understand, Your Honor, of course. But they're often rife with errors. Some of the previous ones have been, but that's a matter for another day. But I did want to draw the court's attention to that and just make sure that the court was aware that these are two separate locations. The arrests were hours later in public land, on public property. And from what I can tell, it's essentially they just arrested whoever was there, whoever they could find, whoever they were able to get their hands on. And I don't see any commonality between these defendants other than, for the most part, their lack of criminal history, the fact that they're from out of town, which is also, it appears that the GBI or whoever was in charge here split defendants up or split detainees up because they were all detained at that point for any number of possible things. They were split up into local people who were from Atlanta and out of towners. Well, the right to freedom of association doesn't stop at the state line. So I don't think that's an appropriate consideration in terms of charging people. It may be for bond, but that's what I'll address.
And acknowledge none of that evidence is before me at this time. Like
yes, ma'am.
That I understand that you're and the parties believe there's a different narrative going on and things went down differently, but I'm not here to determine
understood
evidence. Although who's the sufficiency of the evidence, all of that's for another day.
Yes, ma'am. And the domestic terrorism statute is laughably unconstitutional. That will be addressed at the proper time in the proper forum. So I'll go ahead and talk to you a little bit about my client. They go by Bo. 24 years old, grew up in Connecticut. I've spoken to their father, who's very worried about them. No prior criminal arrest history, as the state conceded. Bo is a junior at Sterling College in the state of Vermont, studying outdoor education, which is part of, I'm sure, what attracted Bo to this particular festival, this particular gathering that occurred. Bo is employed as part of the degree program. It's a requirement of the school. Again, Judge, no criminal history whatsoever. I understand that Bo is, not 100% similarly situated to the other arrestees here in DeKalb County from, I believe, January 18th, who were essentially just camping out and technically criminally trespassing when they were all arrested, when the police descended on this property and evicted them from the location. However, in some ways, Bo is similarly situated in that they reside out of the state, but a reasonable condition of bond would be to require no return to the state of Georgia. There's no reason to believe that they would refuse criminal process or legal process, that they would refuse to return to court. There's no history of failures to appear. There's no history of probation violations. There's no evidence that Bo was involved in any violent acts whatsoever, other than being muddy and allegedly carrying a shield and being associated with a group of people separate from the folks that allegedly committed vandalism. But there's no evidence that Bo committed any act of vandalism at all. If there was, they would have been charged with arson, criminal damage, criminal interference with property, aggravated assault, any number of felonies that potentially could have been charged based on those 50 to 100 people that committed those acts of vandalism. There's no evidence Bo was involved. The warrant doesn't allege the involvement. It's a very tenuous legal theory under which these warrants have been brought. But that's pretty much all I have to say, Judge. Bo is not at all a danger to the community in any way, shape, or form, and I would ask for a reasonable bond.
All right, Mr. Johnson, any response?
Just, Your Honor, that to address why the charges were brought, of course, I can't speak for, the officers who brought the charges, but what I can advise is that I've been informed that, the domestic terrorism charge is the main charge, and that's why that was charged as opposed to aggravated assault or arson, because that's contained within the domestic terrorism charge. In fact, in order to have a domestic terrorism charge, you have to have a felony, that you were engaged in a felony in order to have what you want to happen. In other words, you commit a felony to threaten people to stop doing something or to do something that you want. I mean, that's kind of the very definition of terrorism. You know, an example I've said to several people and even some of the attorneys when we've talked prior to the hearing today is if I don't like the way that my neighbor mows his lawn, I can go across the street and ask him to mow it differently. But what I can't do is go across the street and set his car on fire and leave a note. That's a crime. That's illegal. That's not protesting. That's not doing anything that is constitutionally protected. And so we believe that all of these defendants were engaged in this act, and we believe that no bond should be granted.
Okay. The constitutionality of the statute is also not something before me today. The statute does have a mandatory or it has a maximum sentence of 35 years, which is serious. And the allegations here are serious. And I understand the probable cause is several paragraphs long. The warrant alleges that each of the people I believe that are for me today were part of the group that armed themselves with shields, walked half a mile to the location where police and property were, threw rocks, fireworks, and Molotov cocktails, and set machinery and others on fire. So the allegations are extremely serious before the court today. So based on that, at this point and the lack of ties to the community, I'm also going to deny bond in this case, but y'all can file a motion and be heard before Superior Court in the near future. And in the meantime, we will set your case down for a preliminary hearing, okay?
Do we have a date for the preliminary hearing by any chance?
It has to be scheduled first. But if you have filed your entries, y'all will get notice of that date.
Understood. Thank you.
All right. Thank you, sir. Okay. Next, we have, let's see. I may take a moment to do we have a consent bond on number 5, Mr. Jamari Brown?
That is correct, Judge, for a $5,000 bond and no firearms condition.
All right, Mr. Jamari Brown, could you come up, please, sir? Good afternoon, sir. You are charged in case number 23-019635 with possession of firearm during the commission of a violation of the Georgia Controlled Substances Act and possession of marijuana with intent to distribute. Your attorney, well, let me ask you this first. The warrant numbers are 23W003543 through 44. Ms. Henris, have you had a chance to go over these charges or someone from your office with your client?
Yes, Your Honor. I've read them for all my clients today, except for the one language line case that we previously mentioned.
Okay, thank you. All right, so sir, your attorney indicates she's had a chance to go over the charges with you and is waiving a form. Are you waiving a formal reading of those charges into the record, ma'am?
Yes, Judge.
Okay, and that she is waiving a formal reading of the charges into the record. Do you understand the 2 charges against you, sir?
Yes.
All right. She has negotiated a bond on your behalf, and given your lack of criminal history and the charges before the court, I will go along with that consent bond of $5,000. And you will have a special condition that you not possess any firearms while you are on bond in this case. All right, so you just need to sign that special condition and then you may follow the direction of the deputies, please, sir. Thank you, sir. Right, and everything should be signed and saved on my end. Okay, and then I will pull up Spanish language line. All right, we will just keep going through this case as we go. All right, next we have one of the co-defendants is Amin Chowie, or I apologize for any mispronunciation. All right, good afternoon, sir. You are charged with 1 warrant for domestic terrorism in case number 23W003602. Sir, have you had a chance to go over the charges with your client?
Your Honor, I personally have seen the warrant. We discussed the general nature of what happened. That's what we discussed last night.
All right. Would you like me to read the warrant?
I would like to hear the warrant, yes, sir.
All right. And sir, have you filed an entry? Remind me.
The entry has been filed.
That's right. Okay. And then, all right. So the warrant alleges, just one moment. All right, it charges you with domestic terrorism at the location on Key Road on March 5th of 2023, and that you did attempt to commit a felony violation of these states, which is as part of a single unlawful act or a series of unlawful acts which are interrelated by distinguishing characteristics, is intended to cause bodily harm, kill any individual or group of individuals, or destroy, disable critical infrastructure, a state or government facility, or a public transportation system. Such disability or destruction results in major economic loss and is intended to change public policy. To wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately half a mile in the forest, and began to assault Atlanta Police Department officers and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at risk of receiving serious injury or death. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflaged or dark-colored clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant "Stop Cop City" was repeatedly used. That is the allegation in the warrant, sir. So, sir, do you understand the charge against you?
I do.
Thank you. I will hear from the state on bond.
Yes, Your Honor. This defendant also has what appears to be no ties to the state of Georgia, showing a home address in Richmond, Virginia. This individual was part of that same group that we've been talking about, who engaged in the actions that you just read in the warrant. And based on that, Your Honor, we would oppose the granting of bond because we believe that this defendant is a threat to the community and a flight risk.
All right. Sir, I will hear from you for the defense.
Yes, Your Honor. Without, reiterating the things that Attorney Eli Bandit said before me very eloquently about the defects in the warrants, which seem to be hard copies, no specific really actions that are alleged. I would reiterate a couple things, that in order for, to have a charge of domestic terrorism, as the Citizen District Attorney mentioned, there has to be a felony charge. And it is my opinion and an argument here that without there being a warrant charging that extra felony, the warrant for domestic terrorism is illegal in effect. And we haven't heard any specific, as the defendant pointed before, we haven't heard any specific charge of any individuals, being charged with arson, being charged with criminal, damage, for my client specifically, again, just a repeated charge of dirty clothing and sheep. So this is, I'm going to limit myself as far as talking about that case and the warrant, that I do believe that legally the warrant is effective. Because of there's an underlying felony. Now, if I go into the details of, if I go into the details of my client's personal situation, my client again has never been arrested before. So it's been a law-abiding citizen all his life. I don't think it's a life risk. Grew up in Del City, Virginia. His family still resides there. Went to college in Richmond, Virginia, where he currently resides. He graduated with a Bachelor of Arts in English. Has friends in Richmond. Has a room there that he rents in Richmond. Has at least a 2-year lease, so he's got a place to go. he's going to reside there if he's granted bond. He basically is going to go to Virginia, if he's granted bond. He's got a medical issue that would present a substantial hardship for him to be incarcerated for any duration, substantial duration of time, because there's certain pills that he has to take twice per day. He also has, concerns about whether he's going to be able to practice his Islamic religion in the jail. He continues to be incarcerated. Another thing about Mr. Amin is that he has worked very hard and he has allowed me to talk about this. He has worked very hard to overcome an alcoholism addiction. He has been 5 months sober, never got in legal trouble for it. But he does need to attend Alcoholics Anonymous meetings every day. And I have not struggled with alcoholism before, but I understand that those types of things are very difficult struggles, and any obstacles that we throw in people's way like that, when they have really demonstrated commitment like that for months, to try to stay on a path of recovery, it's not, it's not going to be, it's not a good thing. And plus, being, 5 months sober demonstrates the character of the person that we're looking at, somebody that, is, I think, of a good character, and we'll keep his word if released. We'll return back to the board and stay out of Georgia, if so ordered by the board. And again, we're talking about a law-abiding person here, never been arrested before. One last thing I want to say about, which applies really to all the rest of the people that I personally have spoken to and that I represent, is that they have had no prior participation in this South Cobb City protesting or action. This isn't, somebody that has been sitting in the forest, for months or something like that, like we had the cases back in December or January. This is somebody that has heard about a weekend of, events, as it's been advertised, of music and fun. Came down here, and then as Mr. Bennett pointed out, sort of randomly picked out of the crowd and arrested, and now his life is going to be ruined. So, that's what I have to say.
All right, thank you, Mr. Johnson. Any response?
Your Honor, the only response has to do with the issue that came up about the argument that there needs to be a underlying felony charged. I would just point the court to, which I'm sure you're already fully aware of, that, for instance, felony murder, you don't have to charge the underlying felony of armed robbery or ag assault. If you just charge the felony murder, that's sufficient. So the state's position is there is no legal basis for that argument whatsoever.
All right. Yeah, the weight and the legal basis for the charges will have to be heard on another day, and are not before the court at this time. Base, again, he's similarly situated to the others on a lack of ties to the community and the severity and seriousness of the charges before us and the specific circumstances surrounding the charges before us. I'm going to deny bond and find that there is a significant threat of danger to the community, people and property, in this community, people and property, and a lack of ties to this community. Y'all will be able to file a motion for bond before Superior Court, who will ultimately have your case anyway, and you will be scheduled for a preliminary hearing in the meantime, okay? Thank you, sir. Okay, I'm just gonna keep going with these. I apologize to the public defender. If y'all could just hold on for me, I appreciate it. I know there's been some long days. I'm going to keep going with these while I have this case pulled up. I know that the Attorney Foster and Attorney Katz, did y'all figure out which one of you is representing position 2, Mr. Max Beardeman?
We did, Your Honor. I'm going to be representing them, but I think we're going to.
Yes, and Your Honor, I've had a chance to talk to Ms. Beeman as well.
And Ms. Beeman. Okay, so we will start back at the top. This is the same case number. It's warrant number 23W003585. Jack April Beeman, charged with domestic terrorism. Ms. Foster, have you had a chance to go over the charge with your client?
Yes, Your Honor.
Okay, and are you waiving a formal reading of the charges into the record?
Yes, Your Honor.
All right, thank you. Ma'am, do you understand the charge against you? And you need to answer up towards the microphone that the deputy has pointed out to you. All right.
Yeah.
I'm sorry. Yes. So, Defendant Beeman, do you understand the charge? Beeman, do you understand the charge against you?
Yes.
All right. Thank you. All right, Attorney Foster, I will hear from you. I'm sorry. No, let me hear from the state first, and then I will hear from you, Ms. Foster, what you would like me to know about your client.
Yes, Your Honor. This defendant is charged similarly to the last defendant as far as the warrant language goes. And so the state's position is that she was involved in this group that went from the area that was still illegal, but not engaged in any kind of violent activity, and joined with the group engaged in the violent activity, and therefore should be denied bond because she's a threat to the community. I do show that she does have no criminal history that we're aware of, and that an address of Athens, Georgia. So unlike some of the others, this defendant does show ties to Georgia. So we would request a denial of bond based on a threat to the community based on the actions in the case.
Okay. All right. Attorney Foster?
Yes, Your Honor. My client is a student at University of Georgia, no criminal history, young, these essentially the way that this thing was advertised was as a music festival. So you have someone attending this cause related festival and getting picked up a significant distance away from any of the alleged acts of vandalism or anything. She has family in Savannah. Her father is a business owner, upstanding member of the community. Father, mother, grandparents, siblings, all in Georgia, all supportive of her, and standing by to make sure that she's accountable to the court, to show up, to take all the steps that she needs to take to fulfill the conditions of any bond.
Right. Mr. Johnson, anything else?
No, Your Honor.
Okay. So while she does live in Athens, I still don't have, I have serious concerns about property and persons in the community, given the charges before the court. So I'm going to deny bond at this time, finding a danger to persons and property in the community. And I will let Superior Court hear bond. You may file a motion for bond before Superior Court, and we will schedule your case for a preliminary hearing in the meantime. All right. Thank you, ma'am. Okay. All right. Next, we have same case number, Mr. Max Beardeman. And you are charged in warrant number 23W003589 with domestic terrorism. Mr. Katz, have you had a chance to go over the charges with your client?
I have, Your Honor, and we'll waive a reading of those. We're also going to deal with bond at a different time, Your Honor, I think. owing to the confusion today, and I got some documents from Ms. Foster, and so I
Okay.
prefer to deal with
I
bond.
understand. This first appearance hearing is close in time to the initial incident where everything, it's still very close in time. So,
Understood.
at this point then, based on that, I'm going to go ahead and deny bond based on the facts before me, but that doesn't affect that you can file for bond before Superior Court.
Understood.
Okay, because I find at this point, just from the information I have in the charges, I have no criminal history, but that he is from Massachusetts. Is that correct?
No, he's from Arizona, Your Honor.
Oh, Arizona. I don't know why I had Massachusetts. Okay. And that may have been something that came up in the history. Okay. But yeah, based on that, finding that he is from another state and similarly situated to the others, I will I will deny bond at this time, and y'all can have a bond hearing before Superior Court. In the meantime, we'll schedule your case for a preliminary hearing, okay?
I've entered an appearance, Your Honor, and I think that'd be best.
Perfect. So you should get notice for that.
Right.
All right. Thank you, sir.
Thank you very much.
So, Mr. Biederman, you will have a hearing in the future. Your attorney will get with you for a motion for bond before Superior Court, and as well as your preliminary hearing. And you can just follow the direction of the deputies for now, please. Okay. Next, we have Colin Dorsey. Good afternoon, Mr. Dorsey. You are charged in case number 23W003598 with that warrant is domestic terrorism. And Attorney Foster, I believe you also represent Mr. Dorsey. Is that correct?
Yes, Your Honor. We discussed the charges, but I didn't get the warrant until after Mr. Dorsey and I spoke.
Okay. Would you like me to read the warrant into the record, or are you waiving a formal reading of the warrant?
If you wouldn't mind going ahead and reading.
I will read it for you. There's the allegations in the warrant, not necessarily the PC attached to it, but I'll read the warrant as charged so he understands what that is. Said accused is, so it alleges on that same date, March 5th, at the address on Key Road, said accused did attempt to commit a felony violation of the laws of this state, which as part of a single unlawful act or a series of unlawful acts, which are interrelated by distinguishing characteristics, is intended to cause serious bodily harm, kill any individual or group of individuals, or destroy or disable civil critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss, and is intended to change public policy, to wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately half a mile in the forest, and began to assault Atlanta Police Department officers and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at risk of receiving serious injury or death. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflaged or dark-colored clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant "Stop Cop City" was repeatedly used. So that are the allegation in the warrant for domestic terrorism. Sir, do you understand the charge against you?
Yes.
Thank you. What is the state's position, Mr. Johnson, on bond in this case?
Your Honor, the state would oppose the granting of bond. While Mr. Dorsey has no criminal history, the defendant is from Massachusetts, and this may have been the one you were thinking about, and additionally has a Maine driver's license as well. So ties to, the New England area, but none here in Georgia. And also, this is another defendant who, like some of the others we've heard from, was in possession of a shield when they were arrested. And so that is additional evidence that we believe makes this defendant a threat to the community and a flight risk as well.
Okay. Attorney Foster?
Your Honor, I had not heard anything about a shield from my client. The language in those warrants appears to be copied and pasted. I've talked to my client, and he was, near the parking area, far away from any allegation of the vandalism or any of the actual violent acts, just like the others picked up in this roundup as well. He has we sent to the magistrate email address several character witness letters of people who have employed him or have worked with him in community service. Mr. Dorsey is a agricultural consultant, does work on soil and nature, is in fact has been a member of a Zen Buddhist community and is a practitioner of nonviolence. There's no indication that there'd be any further wrongdoing. Furthermore, I've spoken with his partner Mariah, who is very engaged in the case and happy to help keep him accountable. I think the whole community around him up in Maine is looking to support him in obeying the conditions of any bond and continuing his history of nonviolence and just being a peaceful nature lover.
Okay, thank you. Mr. Johnson, anything else?
No, Your Honor.
All right. I do find that, I hear everyone giving me character evidence, and I do appreciate that. But as I said, that's just part of the equation here. And I'm not here to ultimately determine guilt or innocence. So I do find at this time in this case where the allegations in front of me, there is a significant risk to persons or property in the community at this time. So I will deny bond at this time, but y'all may file for a bond motion before Superior Court, who will get the case ultimately as well. And in the meantime, we will schedule your case for a preliminary hearing, okay?
Your Honor, can I bring up one more thing?
Yes, you may.
This was actually more in regards to Ms. Beeman earlier, but I believe it applies to several of the co-defendants. They're being denied medical treatment. I know that Ms. Beeman has not received her prescription medications that she's supposed to take, but also was injured in the arrests and is not being given medical treatment for significant wounds from the way that she was restrained. So if you could make sure that they all get their medications and are taken care of that way.
But unfortunately, the jail is in charge of that. I would hope that I think they regularly try to do that. I would hope that they do that. People come through here every day with interruptions after being arrested in their medical care. So I know the jail tries very hard to do that. If you have any specific concerns, I encourage you to reach out to them and follow up on that. Okay.
Thank you.
I appreciate that. Thank you. Okay. And okay, the next co-defendant we have is that Maggie June Gates. All right. Good afternoon, Miss Gates. You are charged in the same case number 10-0277-25-22 with one warrant, 23W003591. And your attorney, hold on, I'm not seeing on my screen. Ms. Gates, do you have an attorney in this case?
Yes, Bravo Seaport, Your Honor.
Okay, I can see you there. So, all right. All right. So, have you had a chance to go over the warrant with your client?
Your Honor, same with my previous line, we discussed general, circumstances. I have just now read the warrant. I realize it's hard to copy of one of the previous ones that says shield and dirty clothing, so away to be.
Okay, so you're waiving a reading of the warrant at this time? All right, sir, ma'am, I'm sorry, you're charged with that one count of domestic terrorism in that warrant. Do you understand the charge against you?
Yes, Your Honor.
All right, thank you. Mr. Johnson, what is the state's position on bond in this case?
Your Honor, the state would oppose the granting of bond. Similar to the other defendants that we've heard, this defendant was involved in the attacks, was in possession of a shield. We show that this defendant is from Bloomington, Indiana. There's also mention of a Decatur address. I'm not sure what that address is because the home address is showing as Bloomington, Indiana. So we would argue that she is a flight risk and a threat to the community if released based on the charges and her location.
Okay. All right, and sir, what would you like me to know about your client and what is your request?
Yes, Your Honor, we're asking for bond, here we go. My client, again, never been arrested before, but not at risk. My client does have an address in Decatur. In fact, is renting a house, with a partner there, and so she can stay there. Now, I must say, I don't quite understand this whole, flight risk issue, because if somebody has ties to the community in another state, they are likely to stay there, not abscond somewhere else. So, I don't see how, there's been people granted, the terrorist cases bonds before when they were actually simply told not to come to Georgia. So you would think that would be a good thing. But in the case of Maggie Gates, she does actually have a rented apartment here, a house here in Decatur. So if it is, better for the state, for this case to stay here, she can stay here. And again, a person that's never been in trouble with the law, I think the likelihood to reoffend should be considered as low. Another thing, which is the same thing as with my previous lines that I mentioned, this has been actually the first time that this case has engaged in any kind of participated in any kind of event or protest in terms of defending the court issue. And not somebody that there's any problems with before, sitting in the forest or anything like that. I have received that, and I know that the court is probably wanting to hurry up with the character witnesses, but I've received 3 letters of, character witnesses. One from Nicole Siegel, professor of history and American studies at Indiana University, attesting to his case character, known her for 5 years. This case has been her financial assistant and babysitter. There has been a letter from Laura Bowser, not sure if I pronounced this correctly, from Common Home Farm in Bloomington, Indiana. And Eric Anderson from Strangers Hill Organic Farm. Okay, so there's people that can vouch for, this person being, person of the word, a good moral character, not likely to reoffend, and will follow the legal process. And as a difference from others, this is a person that does have ties to the land and the place. And either that is considered to be better.
All right, thank you. Mr. Johnson, any response?
No, Judge.
Okay, and I will just say one thing, that if someone has ties to another community, there is a concern that they will not come back to this community and they do not have an investment in this community. So that is one of the concerns of the court in deciding whether someone will return to court. Again, I think she is similarly situated to others on this calendar. I'm not, I hear that they have some good character evidence and lack of criminal history. However, given the specific allegations before the court, and the seriousness of the offense, I'm going to deny bond at this stage. She may file for a bond before Superior Court, and y'all will be heard there. I'm going to find that there is a threat to the community, persons, and property. And we will schedule the case for a preliminary hearing in the meantime. All right? Thank you, sir. All right. Next, we have Priscilla Grimm. Thank you. Ms. Grimm, you are charged with, in the same case number with warrant number 23W003600, domestic terrorism. Have you had a chance to go over this warrant, or would you like me to read it to her? Sir, have you had a chance to go over the warrant with your client?
My client would like the warrant to be.
You would like it to be read? Yes, please. Okay, I will read it to you. Hold on, let me make sure I have yours. All right. Okay, Ms. Grimm. Ms. Grimm, your warrant alleges that All right, Ms. Grimm, your warrant, it says that on that same day and time at that same location, you did attempt to commit a felony violation of the laws of the state, which as part of a single unlawful act or a series of unlawful acts, which are interrelated by distinguishing characteristics, is intended to cause serious bodily harm, kill any individual or group of individuals, or disable or destroy critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss and is intended to change public policy. To wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately half a mile in the forest, and began to assault the Atlanta Police Department officers and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at risk of receiving serious injury or death. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflaged or dark-colored clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant Stop Cop City was repeatedly used. So, ma'am, that is the allegation against you. Do you understand the charge against you, ma'am?
I do.
Thank you. Okay, what is the state's position in this case, and anything you want me to know?
Yes, Judge. The state would oppose the granting of bond to this defendant. In addition to what you just read to the defendant, Judge, this situation also involves, similar to the other defendants, that muddy clothing from breaching the embankment, which they had to go across to come from the concert, was identified on her and was also in possession of a shield. This defendant also appears to have no ties to the local community, with a home address of Brooklyn, New York. And so, Judge, we would oppose the granting of bond based on this defendant being a threat to the community if released and a flight risk.
All right, thank you. And I will hear from the defense what you would like me to know about your client.
Yes, Your Honor. My client, has no prior convictions, works for Fordham University. Before that, worked for Creative Circle as an email marketing specialist. She does live in her apartment in Brooklyn, New York, but has strong ties there. Obviously, been living there since 2020. Her daughter lives there, her Ms. Grimm was born in Atlanta, she spent her childhood in Atlanta. Her friends, the friends in Atlanta from 30 years ago that she had, went to Emory. She, she returns to Atlanta, on a regular basis. I understand about the ties that she has to Atlanta. Her domicile, yes, is in Brooklyn, New York. Has had a stable life, and is not going to disappear somewhere because that would mean that she wouldn't be taking care of her daughter, or the uncle. As a matter of fact, she loses her job because of being, incarcerated for an extended period of time. That's going to be a problem for, paying for the home health aid for uncle. And that's gonna be a problem. I received also a character letter from Ellen saying that that uncle's daughter-in-law was outskirts care for that uncle. Again, as previous defendants, that arrived here, shortly before this event, which was sort of advertised as a week of action, as people thought they were going to a concert and doing some activities, and she hasn't participated in Stop Cop City action before, and will not, if ordered so, and granted bond, will not do that in the future.
All right, thank you. Mr. Johnson, anything else?
No, Your Honor.
All right. I do have some concerns about the lack of ties, given that she now lives in New York. But even more so, I still find that the charges before the court, the seriousness of the offense and circumstances surrounding the arrest, I'm going to deny at this point, and find that there is a threat to the community and a lack of ties. But you may file for a bond modification or a bond motion in Superior Court, and we will set your case down for a preliminary hearing, or get that scheduled in the meantime, okay? So thank you very much, and you may follow the direction of the deputies, please, ma'am. Okay, next we have Luke Harper.
Yes, Your Honor, driver C part also for Luke Harper.
All right, thank you, sir. Let me get your client pulled up. All right, good afternoon, sir. You are charged in the same case number in warrant number 23W003581 with one count of domestic terrorism. Have you had a chance to go over the warrant with your client, sir?
Yes, Your Honor.
Okay, great. So are you waiving a formal reading of the charges into the record?
Yes, Your Honor.
All right, thank you. So Mr. Harper, do you understand the charge against you?
Yes, Your Honor.
Thank you. What is the state's position and request on bond in this case?
Your Honor, the state would oppose the granting of bond to Mr. Harper in this case. Mr. Harper is similarly situated to the other defendants that you've heard from and you've seen the warrant. This defendant is also another defendant who on the warrant shows that he was in possession of a shield and wearing the dark clothing and the mask. He is from Lake Worth, Florida, and is another out-of-state individual who appears to have no ties to the community. And so based on that, we would request that he be denied bond because he is a threat to the community and a flight risk.
All right, thank you. And what would you like me to know about your client and what are you asking for in bond?
Yes, Your Honor. My client likewise has never been arrested before. He has a bachelor's of science in business, marketing degree. He's a freelance copywriter and works on projects in that area. He does live in Florida. I have to say, 5 different character letters, and I must say that happening overnight, 5 different people thought that strongly of Mr. Harper, I think should be, something. I got a letter from a, graduate instructor from Columbia University about, Mr. Harper being a, community volunteer. A letter from Wendy King, Executive Director of Immigration Action Alliance. Got a letter from Greenstone Governance, which is a former employer, praising Mr. Harper. Got a letter from Kyra Jennings from the Red Community Land Trust Board. That was talking about how he volunteered there to improve the land trust property. And also from Rachel Big from, Food Not Bombs, which is a communication. And in this particular case, we believe that, with no prior arrests and, there being a good moral character is defended. And also, another common thread that I keep repeating is that, Mr. Carter did not even actually know what he was coming to Georgia. He was invited by his friends saying, we're going to Atlanta, visiting a park and attending some events, and he learned about it on the way here. What this was about. And he understood that it was going to be a week of music and dance. So not really somebody that is dead set on sort of protesting, as he seemed to be an implication from the charges. And one last thing is Mr. Harper's medical condition. He needs to take medication twice per day. That it has been instructed already, and he needs to be able to be instructed.
All right, thank you. Mr. Johnson, anything else?
No, Your Honor.
Okay, so I do find he's similarly situated to our other out-of-state defendants. I am going to deny bond at this stage based on the threat to community and property here and a risk of flight based on his ties to other states and lack of ties here. In the meantime, you may file a motion for bond before Superior Court Judge, who will have the case, and we will schedule your case for a preliminary hearing. Also, any concerns you have about medications or anything, I would ask that your attorney be sure to communicate that to the jail while he's there, so they can hopefully make sure that information is on your file and being taken care of. Okay? So I appreciate it, and you may follow the direction of the deputy, sir. All right. Okay, next we have Mr. Thomas Webb Jurgens. And I believe this is one that you mentioned may be a consent, Mr. Johnson.
Yes, Your Honor.
And I will just need to hear why he would be differently situated from the others we've had so far.
Yes, Judge. That's it.
But let me go ahead and get him. Is Mr. Jurgens at the podium?
Yes, Your Honor. Good afternoon.
All right, good afternoon. Mr. Jurgens, you are charged in that same case number 10-0277-25-22 with domestic terrorism. In warrant number 23W003583. Your attorney, have you had a chance to go over the warrant with him, sir?
Yes, we actually have not had a chance to do it. No, but I'll wait. Yeah, we won't wait, Your Honor.
Okay, you're gonna waive. All right. So your attorney has indicated that you're waiving, and you indicated that you're waiving a formal reading of the charge into the record. Do you understand the charge against you, sir?
Yes, Your Honor.
Thank you. Okay, so I understand the parties have reached a proposed consent order in this case. Mr. Johnson, let me know why he may be differently situated from, say, our person who was from Athens.
Yes, Judge. So just to give the court a little bit of background on this particular defendant, we were contacted by the Southern Poverty Law Center to find out about what was going on with Mr. Juergens' case. The reason being, Mr. Juergens is an employee of the Southern Poverty Law Center. He is a lawyer barred in Georgia and I believe in another state as well. I checked and he is an attorney in good standing with the state of Georgia as of today. The claim that was being made in talking to his attorney yesterday, Mr. Bass, is that Mr. Juergens was there as a legal observer and that he was there more to observe what was going on and see what was going on. I will say this, Judge, this is a dynamic case and a fluid investigation. Simply because you're an attorney doesn't mean you can't commit a crime. We've obviously seen, unfortunately, many attorneys, doctors, dentists, all sorts of people commit crimes. However, given the fact that he is a barred attorney, his claim at this point is that he's a legal observer and that at this stage right now, I can't stand here and say like a witness saw him throw something in particular, that we're not saying that there's not potentially a case against Mr. Juergens down the road. But at this stage, based on all of those things, we would consent to a bond and that part of his bond be that he have no contact with the co-defendants, that he stay away from the area of Key Road and Constitution Road where the location is, report to pretrial services as required, all of those things. And again, given that he is a barred attorney in this state, we would consent to a unsupervised judicial release for that bond on this particular defendant, given his background. So that's the basis for that, Judge.
Okay. An attorney comes before me on a DUI, they may not necessarily get a different bond based on being an attorney.
Yes,
They cut both ways. Given that you're saying he's a legal observer,
Your Honor, I would like to add this.
Yes, go ahead. You can be heard as well, of course.
All right, thank you, Your Honor. I want to add that Mr. Juergens was wearing a National Lawyers Guild hat, it's a bright yellow hat, as well as a bright green shirt. These things identify him as a legal observer. There's really not much more to say about that. I will add that there were also waiting to be audited if we want to bring a character witness in, and that is something we did in order to agree to the consent order that we're trying to reach here. So I'm happy to bring that evidence to the record as well. They're in the waiting room for those who call.
Okay. I feel like given the severity of the offenses, there needs to be some sort of bond. Because obviously I hear what y'all are telling me, but in the charges before the court, that none of that is in there, right? And this isn't where we determine that. So I just need something to ensure. I understand he's an attorney.
He's barred in 2 states, and obviously that's one of the many things that he risks losing if he doesn't show up at court later. So I
understand that. It's
granted.
Okay. So.
I'll also add that he is an employee here. I know that Mr. Johnson said that, but his employment is right here and now. He's got a job to go to.
And obviously my concerns are the risk to persons or property in the community. And I hear what y'all are saying, but I'm also knowing that I'm not deciding where charges end up today. That's not my decision. I just want some assurance that he has a reason to not contact the co-defendants in the case going forward, and that he stays away from the location. And I feel like there should be some sort of monetary bond attached to that.
Add to that, it seems to me that lawyers know to obey court orders. There's a lot of risk of not doing that.
So they do, but we have lawyers who commit all kinds of crimes, unfortunately. at times. And so, and they also know the law and so I'm going to set bond in the amount of $5,000. All right. With the same conditions that you have no contact with the co-defendants and stay away from that location.
Thank you, Ron.
All right. So let me get that filled out so you can sign that special condition, all right? Just one moment. Sorry for the pause. It takes a minute to refresh.
Nowhere to be, Your Honor.
It's not loading yet. Yeah.
All right, hold on, everybody. And is this one that y'all are comfortable with me drafting, or is that one that y'all would prefer to draft yourselves and send to the court?
I have no opinion. I'm comfortable with you doing it, Your Honor.
I'm fine with the court doing it, Judge.
Okay, let me just get the location in there. Hold on. And my VPN just disconnected, so give me 1 minute. We've been And do y'all think he's going to be able to make that bond, or do you want to reserve his preliminary hearing?
Yes, he's going to be able to make that bond, Your Honor.
Okay, so are you going to waive his preliminary hearing?
Yes, that we are going to waive the preliminary hearing.
Fine. So 1 moment, it's pulling back up. Okay.
Madam Clerk, when you print that, I need 3 copies.
All right, it should be saved now. Let me see if it may have not done my signature. Just a moment. Okay. All right, Madam Clerk, you should have everything saved at this point. Okay. So I believe everything is saved. Is everything signed? Once he signs that special condition, he can follow the direction of the deputies and also the waivers. Let me make sure the waivers on there.
The waiver is signed, Your Honor.
All right, let me double check the special condition because there was an interruption. All right, everything should be signed on my end.
She's confirmed it is signed and it's signed.
All right, thank you. So, sir, you can follow the direction of the deputies at this time.
Thank you.
Thank you. All right, next we will pull up Ms. King. Elegla King.
Drive the street car for Ms. King.
Thank you. Have you had a chance to go over the warrant with Ms. King?
We did not, if we can read it.
All right, I will do that. Moment. Okay, Ms. King. You are charged with one warrant, warrant number 23W003596, and the same case number with domestic terrorism, in that you did attempt to commit a felony violation of the laws of the state, which, as part of a single unlawful act or a series of unlawful acts, which are interrelated by distinguishing characteristics, is intended to cause serious bodily harm, kill any individual or group of individuals, or disable or destroy critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss and is intended to change public policy. To wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately a half mile in the forest, and began to assault Atlanta Police Department officers and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at risk of receiving serious injury or death. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflage or dark-colored clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant "Stop Cop City" was repeatedly used. So, ma'am, that is the allegation against you. Do you understand the charge, ma'am?
I do.
Thank you. I will hear from Mr. Johnson on the state's recommendation in this case.
Yes, Judge. The state would oppose the granting of bond in this case. This defendant, again, similarly situated to the other defendants that we've heard today, additionally was also found in possession of a shield and has no ties to the local community, is from Worcester, Massachusetts, and based on that, we would oppose the granting of bond because she is a flight risk and a threat to the community.
Okay. All right, and I will hear from defense counsel on bond at this time.
Your Honor, again, my clients have been arrested before and everything, the law. Yes, she lives in Worcester, Massachusetts, but, you know, has family and friends there and is going to stay put and not going anywhere. So, likewise, never been to Atlanta before. First action of, you know, first protest or whatever you want to call it related to this defend Atlanta forest issue. Not a pattern of any kind of, you know, even if you call this undesirable behavior, certainly not been in trouble with the law before, no illegal behavior. So they're supposed to start a job on the 17th, for CNC machining, which involves cutting metal, using computers. So, continuing incarceration will interfere with the job, prospects. And, they also take care of their, have two brothers, they're age 8 and 10, and helps, their mother to, take care of the brothers. Also, King has a medical issue that requires medication every day. And again, continuing incarceration will interfere with the medical treatment. This is pretty much all I have right now, considering that everything else would just be reiteration of previous issue from, we're dealing here with guilt by association and not going to the past.
I understand. And obviously, like I said, I'm not here to determine that. It could also be parties to a crime. And it's similarly kind of what they're charged under, which is why they're before me. The weight of the evidence will be determined at a different court on a different day. Mr. Johnson, do you have anything else you would like to add?
No, Your Honor.
Okay. I do find that she's similarly situated to the others who are not from the state. I am going to deny bond at this stage, based on a flight risk and a threat to the community. And y'all can file a motion for bond in Superior Court, who will have the case. And we will schedule your case for a preliminary hearing in the meantime. And any medical issues that you referenced, you are welcome to please talk to the jail about that to make sure all of that is straight for your client. All right, thank you. Ma'am, you may follow the direction of the deputies.
Thank you, Your Honor.
All right. Okay, the next co-defendant I have is Zoe Claire Larmy.
Your Honor, driver Steve Power also here for Zoe Larmy.
All right, thank you. Good afternoon, Ms. Larmy. You are charged in your warrant in 23W003595 with domestic terrorism as well. Have you had a chance to go over the charge with her, sir?
No, Your Honor. So we would like to read the entirety.
Okay. You would like me to read it in the entirety?
Yes, Your Honor, or if there's any distinguishing wording in the wording from previous.
It's fine. I'll just read it because I don't want to make any assumptions about any distinctions between the different warrants. So I'll just read it. It's kind of similar when we have multiple parties charged in a single case. So I think they are all very similar. This warrant is for domestic terrorism on that same date and time, in that said accused did attempt to commit a felony violation of the laws of the state, which as part of a single unlawful act or series of unlawful acts, which are interrelated by distinguishing characteristics, is intended to cause serious bodily harm, kill any individual or group of individuals, or disable or destroy critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss, and is intended to change public policy, to wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately half a mile in the forest, and began to assault Atlanta Police Department officers and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at risk of receiving serious injury or death. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflaged or colored dark clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant "Stop Cop City" was repeatedly used. So, ma'am, that is the charge against you. Do you understand the charge against you?
I understand, Your Honor.
Thank you. All right, Mr. Johnson, what's the state's position on bond in this case?
Your Honor, the state would oppose the granting of bond for this defendant. This defendant is also from out of state. It shows that Nashville, Tennessee is Ms. Larmy's home. Also, in addition to what you read in the warrant, this defendant was also found in possession of a shield, similar to some of the other defendants you've heard. And based on all of that, we would request that you deny bond based on the fact she is a flight risk and a threat to the community.
All right. I will hear from defense and what you would like me to know about your client.
Yes, Your Honor. My client has never been arrested before, and is not a risk to reoffend. In addition, and comparatively to other defendants, I would say, Nashville's a lot closer than New York, and I don't think that geographical location, part of Georgia might be harder than a part in Alabama. So I don't think the state line is really the determining factor here. But yes, my client lives in Nashville. Her parents own a house there. She lives there with her twin brother. She works part-time as a project manager for a school system in Charlotte, North Carolina, the most time of work. And obviously will lose her jobs, if continues to be incarcerated. Has a college degree from University of Virginia, Bachelor of Arts in Political and Social Thought, and Bachelor in Cinematography. Also, like the previous defendants, this was the first engagement with this stop custody or defendant divorce type issue. And another distinguishing characteristic for Ms. Larry and the hardship that is unlike other defendants is that she does have a medical appointment. Well, it was scheduled to get a biopsy done, and that had to be moved because of this incarceration. But it will have to be done soon. We all know, what the biopsy is and what it's for, and what that means. So with that,
All right, thank you. Mr. Johnson, anything else?
No, Your Honor.
All right, again, I think she is similarly situated to the others who may have come here for the first time and ended up charged in this case. But I find that there is a flight risk as well as a threat to the community, persons and property in the community at this time, at this stage of the case. So I'm going to deny bond at this stage. Y'all can file for a motion for bond before Superior Court and be heard there. And we will also schedule your case for a preliminary hearing as well. Okay? So thank you. I do appreciate your attorney's efforts, and please follow the direction of the deputy.
thank you.
Thank you. Let me just correct one thing. All right. One moment. I need to make sure. It looks like I need to. Good afternoon. Just one moment. I had a little glitch I need to fix. All right. So now we have Mr. Dimitri Lenny.
He speaks French.
Oh, he needs a language line?
Yeah.
Okay. I speak French too, but not well enough to interpret. So we will hold him for the language line. Thank you. And that's Mr. Lenny is French? Okay. All right. Okay, then we will have Mr. Mattia Luini. All right.
Good afternoon, Your Honor.
Good afternoon. Have you had a chance to go over warrant number 23W003584 with your client?
I haven't had a chance to go through the warrant, and I just got, in the middle of this hearing, but we have spoken about what the charge is. And
Okay.
would waive the, reading of the warrant.
Okay, so you will waive reading of the warrant. So, sir, do you understand the charge against you?
Yes.
Thank you. All right, Mr. Johnson, what's the state's position in this case?
Your Honor, the states would oppose the granting of bond for this defendant. This defendant, you've obviously read through the warrants and know the situation. This is another defendant who is also in possession of a shield. So I think that adds to it as well. This defendant is from New York and has no appreciable ties to the Atlanta, Georgia, or Decatur community. And so we would oppose the granting of bond that this defendant is a threat to the community and a flight risk.
All right. And I will hear from the defense counsel on bond.
Yes, Your Honor, and I do have Mr. Lee's mother in the waiting room. Kayla Margiani, so I would like to call her later.
That's fine. You can tell me what you would like me to know, and then we can bring her in from the waiting room.
Yes, Your Honor. Mr. Lee doesn't have any significant criminal history. He is from New York. That's where his mother lives. He's also a cook. Was previously working at I believe it was in building by John Gordon and Mr. Lee, Mr. Lee started the warrants, as the state points out, is exactly the same as all the other charges. It's not specific to Mr. Lee, and I understand the seriousness of the crime is severe, however, the seriousness of the circumstances here is questionable, given the fact that every individual there's nothing specific about Mr. Lee's case circumstances, apart from any of the other defendants. And Your Honor, if I could call Ms. Michaela Martigani, his mother.
Okay, I do see her in the waiting room. Madam Clerk, could you please bring her in? Ma'am, could you please turn on your video and unmute? The officers and troopers at risk of receiving serious injury or death, multiple pieces. Why do I hear ourselves in the background?
I'm not sure, Your Honor.
Ma'am, you're not recording anything, are you?
I believe she may have joined the Zoom late.
Okay, maybe that's what's happening. All right, Ms. Martigani, can you unmute, please? On the state's recommendation in this case. So,
Yep.
ma'am.
State would oppose the granting of bond in this case.
Ma'am, why do you know why do you have two devices going?
Other defendants that we've heard today.
Do you have YouTube on?
Possession of a sheet.
There we go. Okay. Did you have YouTube on?
Yes, sorry.
Okay, that's what that was. Okay, thank you. All right. Okay, so Madam Defense Counsel, you may question your witness. Swear her first, please.
Yes, can you raise your right hand? Can you swear to tell the truth, the whole truth, and nothing but the truth?
I am. Can I ask you? Go ahead.
Is it Ms. Martigani? Can you state your name for the record?
Michaela Martigani.
And Ms. Martigani, why are you here today?
Well, I am the mother of another defendant, Mattia Luini.
Can you describe his general character?
Absolutely. Well, I could say, obviously, I'm his mother. I can say many things about him that is sweet and caring, and that he is always believed against all odds about, the goodness of humanity. He's worked his entire life for the good of human beings and the planet, and it couldn't ever hurt a fly. But I also noticed that at this point, character witnesses is not what is needed, or the judge said this is not the right place. So the only thing I can say is that he is an incredibly principled individual, and so am I, and he would never, ever not present himself in court when summoned. And in addition to that, I would like to take full responsibility myself as well.
Ms. Martigani, where do you live?
In New York.
And if your son was to be released on bond, where would he stay?
He would stay with me in New York.
And would you be able to assure his presence and ensure that he shows up for his court case in Georgia?
Absolutely, yes. There is no way he wouldn't be there for that.
And do you have any reason to believe that your son would flee or he wouldn't appear for his court case in Georgia?
No.
Your Honor, at this time, those are all the questions I have for Ms. Martigani.
Okay, and I will allow Mr. Johnson to ask any questions if he has any. I will note, I didn't say that this is not the place for character evidence, but it is one thing I'm considering that I have to balance with everything else. And so I do consider it, and I'm not disputing that everyone who said the different people who do have good character, but I also have to look at other factors as well. So, Mr. Johnson, do you have any questions for this witness?
No, Your Honor.
All right. All right. Thank you, ma'am. You're excused.
Thank you.
Come on.
All right. Anything else from the defense?
No, Your Honor, I would just like to reiterate what all of the previous attorneys have said about each of their clients and what has already been said in regards to this case, the series of circumstances, and the fact that this really doesn't have any serious criminal history. There is no reason to be concerned that he would not appear for his court case in Georgia.
Okay. I do find that he is similarly situated to the others. I know everyone is saying that everyone has very good character, even those out of state, but I have the charges that are before me, and the weight of the evidence will have to play out later. But at this point, I am going to deny bond. At this stage, you may file a motion for bond before Superior Court, and we will schedule your case for a preliminary hearing in the meantime. And thank you very much, and please follow the direction of the deputy. And then next, I have Mr. James Marsicano.
Good afternoon again, Your Honor. Eli Bennett on behalf of James Marsicano.
Good afternoon. And I'm sorry, I don't have a running tally of who has how many cases left. So I'm just going to go down the line as I can.
Not a problem, Judge.
All right. So Mr. Marsicano, good afternoon. You are charged in the same case number as the others with warrant number 23W003603. Have you had a chance, Mr. Bennett, to go over the warrant with him, or do you know if anyone has?
We have discussed the charges. We have not explicitly discussed the warrant, but I am authorized to waive reading, and we'll make sure they have a copy of the warrant post haste.
All right, thank you. Mr. Marsicano, your attorney indicates that they are waiving a reading of the formal warrant or the warrant and its formalities into the record. Do you understand the charge against you, sir?
Yes, Your Honor.
Thank you. State, what is your recommendation? What would you like me to know on bond?
Yes, Judge. The state would request that bond be denied for this defendant. He is from Charlotte, North Carolina, and has no ties to this community. And he was also another individual based on the warrant that was found in possession of a shield in addition to all the other allegations contained within the warrant that you're aware of, Judge, already. And based on all of that, we would request that bond be denied, that he is a threat to the community and a flight risk.
All right. And I did see that there were some recent arrest cycles out of New York, but no convictions at this time. So, or that was provided to me. Mr. Bennett, what would you like me to know about your client and bond?
Yes, Your Honor. Very briefly, contrary to counsel's representation here, my client actually is pretty well familiar with the Atlanta area, has a large group of acquaintances and friends, any one of whom he could reside with during the pendency of this case. And I may have been remiss in not bringing this fact to counsel's attention that Jamie, as they prefer to be called, is a second-year law student at UNC Chapel Hill. The individual before you was present in part as a legal observer in a much similar capacity to Mr. Juergens. Jamie worked at the nonprofit called the Bail Project for approximately 2 years and also interned with the Public Defender's Office in Charlotte, North Carolina, and was inspired to attend law school as a result. He is also the president, they are also the president of the National Lawyers Guild Club at UNC and is on a 90% scholarship and has already missed several classes as a result of this arrest. The prior arrests that the court mentioned are all protest related. They were all resolved with either deferred adjudication or dismissal. There's no history of failure to appear in court. There is no history of probation violations or refusal to respond to legal process. So, just to the court's point that the question ultimately is what distinguishes Jamie from the other defendants here. I would suggest that Jamie is similarly situated to the individual to whom the state had no opposition to bond. There is no additional evidence against Jamie that I'm aware of and that's listed in the warrant. And I presume, without having seen Mr. Juergens' warrant, that the quality of the allegations are at least substantially similar. So I would respectfully request that Jamie got caught up in this, was not involved in any violent acts, any acts of vandalism. The only differentiating factor that I've been able to determine is that Jamie followed what typically we get advice in law school, which is do not incriminate yourself, don't speak to law enforcement, even if you have nothing to say other than I didn't do it and I'm not involved. And I feel like there may, a common factor here may have been, people being punished for exercising their right to remain silent because you didn't assist the police in doing their job and trying to actually identify the suspected vandals. You're being punished with this domestic terrorism allegation, which will not hold up in court. And I understand this isn't the proper forum for that, but Jamie meets the Ayala factors, Your Honor, and we would respectfully request a reasonable bond with conditions as the court sees fit. There are conditions that the court can impose that will guarantee, at least reasonably guarantee, the safety of the community and Jamie's attendance in court to fight these allegations.
So, Mr. Johnson, do you have a response to that?
I do. I don't believe they're similarly situated. I understand what Mr. Bennett says, and I have no reason to, disbelieve that that's what he's been advised by his client, I'm assuming. But I have no information that he identified as a legal observer, whereas it was different with Mr. Juergens. I also have evidence from this warrant that he was in possession of a shield, which shows, I've read a lot between about probably yesterday and today about legal observers and what they're supposed to do and what they're not supposed to do. And they're not supposed to engage, is what they're not supposed to do. They're supposed to stand off. And so, I would say that this defendant is different than Mr. Juergens based on the facts. He is also not a barred attorney, and he was not, an employee of the Southern Poverty Law Center. And those are things that weighed in the favor of Mr. Juergens being granted a bond. Again, as you said, this is merely the first appearance. It is not the trial. And so we would request that he be denied bond as he is a threat to the community and a flight risk.
Your Honor, if I may,
You may.
I've been informed that there are 2 witnesses who would like to speak on Jamie's behalf that are in the Zoom waiting room. One of them is Veronica, and should be identified as such in the waiting room. Veronica Benson Thornton, who's an Atlanta resident, and could testify that he could reside, I presume, with her, and to demonstrate some additional ties that Jamie has to the community, and also a practicing attorney in North Carolina who has worked with Jamie on similar matters to these. So if the court would be inclined to temporarily admit them for the purposes of telling the court what they'd like you to know in favor of this bond determination, Your Honor.
That's fine. I will hear from them. We'll admit the first one. I think we're admitting Miss Thornton.
Ms. Thornton, can you hear us?
She is not connected to audio. So we're gonna have to place her back in the waiting room because I'm not sure how we can, you can text her maybe. Did she reconnect?
I believe that at least my.
Oh, it looks like it's connecting now. So, oh, she's connected now. All right, you may swear her and call her, or call her and swear her.
Ms. Thornton, could you please raise your right hand? Do you swear or affirm the testimony you give before this court today will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay. Ms. Thornton, could you please identify yourself for the record? There may be some connectivity issues going on, Ms. Thornton.
Yeah, her connection does not sound good.
Okay.
I mean, you can proffer what her testimony would be.
Your Honor, I would, but I don't have that information at hand.
Oh, okay.
So I believe we could potentially move on to the next witness. I don't think the connectivity issue is going to resolve itself.
Okay. Who is your next witness?
That would be Xavier, who is a colleague of Jamie's that would like to speak.
A colleague, is that Xavier? Okay, got him. All right, he should be joining.
Okay. Good afternoon, sir. Could you please raise your right hand? Do you swear and affirm the testimony you give before this court today will be the truth, the whole truth, and nothing but the truth under penalty of perjury, sir?
I do.
Okay. Xavier, can you please identify yourself for the record?
Good afternoon, may it please the court. My name is Javier De Janon, that's Xavierdejanon, and I am a North Carolina and South Carolina licensed attorney.
Could you tell us how you know Jamie?
Yes, so I know Jamie for many years. I connected with Jamie some years ago in working in a post-conviction relief matter that Jamie was integral in getting support to someone behind bars. Since I knew Jamie, this was about 4 years ago, I can attest that Jamie is committed to helping people and to making a positive impact in the world. I have interacted with Jamie in many forms since that incident. As was mentioned, Jamie was also integral in starting a nonprofit to provide bond support. And on top of that, in Charlotte and in Atlanta as well, Jamie is essential in providing resources to people who might not have them. For example, connecting people to housing, connecting people to food, connecting people to daycare. I have gotten closer with Jamie through the years, and I actually was able to advise Jamie in going to law school and recommend that this was a really good path for them. If there's anything, they're very determined. And because of their brilliance, as was proffered, they were admitted with a 90% scholarship. I have had the the blessing, the fortune of being close to Jamie, and the outpouring of support that Jamie has received is inexplicable. I'm a criminal defense attorney myself in North Carolina and South Carolina, and I'm familiar with this kind of hearing, and I know people say a lot of things, but for me, it is rare for me to be able to say that I can personally attest to Jamie's good character, that I can personally attest to Jamie's peaceful character, and that I can also personally attest that Jamie does have ties to Atlanta. The person who had joined the call, Miss Veronica, I do have her address. We refer to her kindly as Auntie. Her address is 7918.
Stop. Okay, I'm going to ask you not to say anybody's address since we are streaming live.
Understood, Your Honor. I will leave it to.
Yes, leave it to his attorney. I hear that you have an address for him in Atlanta.
Yes, for Miss Veronica in Atlanta. I cannot emphasize how much of a support system Jamie has. And I understand that the court's concerns are with alleged violence and alleged flight risk, but just like Mr. Juergens, who we heard from before, Jamie is in the career path to become a licensed attorney. And they're in the second year of law school in the top tier of their law school. They're actually in the top third. I believe this places Jamie in a very similar situation as Mr. Juergens. And I believe that Jamie does have a village behind them to make sure that they come to court, to make sure that they follow the conditions that the court imposes. And I do not believe that there are enough facts to indicate that Jamie is a threat, as has been stated by the government. When we found out that Jamie had been arrested, Your Honor, it felt like the sky was falling. The sky was falling on the entire community because Jamie's presence in our lives is so essential, because people depend on Jamie beyond me, beyond my friends. There's people who I don't even know who depend on Jamie. I know that us as their community won't let their soul break. I know that the state won't break our soul. And I also know that I can personally guarantee that Jamie will come to court and will follow the court's orders.
Thank you, Xavier. I have nothing further, Your Honor.
All right, Mr. Johnson, do you have anything for that witness?
No, Your Honor.
All right, you may be excused, sir. Thank you. All right, anything else from either side?
Your Honor, I do have a couple of character letters that I could submit to the court.
You can, and you can summarize them as well.
I have a character letter from Xavier, who you've heard from today. Just opened the wrong one. Sorry. Jamie is an advocate for human rights, Your Honor. That's what brought him to Atlanta. That's what brought him into this situation. As what I understand, as a legal observer in a professional capacity, he's very well respected. He's on a path towards becoming a licensed attorney. Hopefully this does not set him back. And we would ask for a reasonable bond.
All right, Mr. Johnson.
The only thing to add, Judge, is while we were listening to the last witness, I went and looked at the bookend photo for Mr. Marzicano, and he's wearing a black shirt, which is not anything having to do with a legal observer, and in fact is corroboration of wearing the black clothing that was there that day. I'll just, for what that's worth, I'll throw that there. We would still request that you deny bond, Judge.
All right. I think at this time, given his ties to other states as well as the other Mr. Juergens was a Georgia bar attorney, and there was proffered to the court that had also been provided to the state specific things backing that up. I'm not going to make that determination this time. I think what I have before me, I'm still going to deny bond that he is a threat to the community and property and persons, and also possible flight risk given the ties to other states. But obviously, if you have any further information on his possibly being an illegal observer, and that gets forwarded to the state and y'all come to some agreement at that point, that's up to y'all. But at this point, at this stage, I'm going to deny it. You can file for a motion as well as approach the state another time if you have further evidence of what you would put forth to the court. And y'all can talk on that, but we will schedule it for a preliminary hearing in the meantime. Okay?
Yes, Your Honor. And just for the record, Juergens was also wearing a black shirt for what it's worth. I understand the court's ruling and that's not going to affect it. I just want to make sure that was known.
Yeah, that wasn't the whole sum of it, but I do thank you for pointing that out to me.
And Your Honor, Mr. Juergens, actually, I looked at his as well, was wearing a green shirt, which was similar to his green hat that he was wearing. So that's inaccurate.
Okay. Well, that's not what I'm hanging my hat on in this case anyway.
Of course.
So okay, I understand. All right. So that will be my ruling in this case. Mr. Marsicano, your attorney will be in touch about any future court hearings and bond hearings and such. Okay. Thank you. And that was Jamie Marsicano. Now we have Grace Martin. Good afternoon, Ms. Martin. You are charged in the same case number 10-0277-25-22 with one warrant, 23W003601, domestic terrorism. Do you have an attorney, ma'am?
Yes, Your Honor, Jennifer Hyman, I'm right here.
Oh, that's right. Sorry, I couldn't see very well. I was looking for squares. Thank you. All right, Ms. Hyman, have you had a chance to go over the charges with your client?
Like with my last client, I haven't had a chance to go over the warrant. We have discussed the charges, so I would wait for reading of the warrant.
Okay, thank you. Ma'am, your attorney indicates that she's waiving a formal reading of the charges against you. Do you understand the charge against you?
Yeah.
Thank you. All right. What is the state's request on bond and what would you like me to know?
Yes, Your Honor. The state would oppose the granting of a bond today for this defendant. You've had a chance to see the warrant, and so the facts are similar as they apply to Grace Martin. In addition, the warrant also includes the information that this accused was in possession of a shield. And this is another defendant who, like so many of the others, is from out of state. Madison, Wisconsin is her home of record. And so based on all of that, Judge, we would oppose the granting of bond because she is a threat to the community and a flight risk.
All right. Thank you. Ma'am, what would you like me to know about your client and what are you asking for on bond?
Yes, Your Honor. First of all, I would like to point out that prior to even receiving the warrant, my client and I had discussed certain things, and it appears that when Ms. Martin was detained, the police actually commented on the fact that she wasn't money, even though the warrant said that she was money and that she was money like every other person. It's again another case. And yes, while Ms. Martin is not from the Atlantic, she is from Wisconsin. She is a very strong ties in that community. She was born and raised there. She graduated from the University of Wisconsin Madison last year. She has a job that she is going to be starting. She worked as a fellowship previously for a nonprofit organization in Wisconsin, and then she is going to be starting a job the next month. On April 4th, in fact, for Epic Healthcare Software Systems as a quality manager. Ms. Martin has not previously been to the subject area. She only arrived about a day prior to this. Her intention was to attend several different service events that were being planned throughout the week. In regards to whether she has any harm to community, Ms. Martin actually is very involved in her community in Wisconsin, and she plans to attend events here in Atlanta to talk about workshops about how to engage with the community, how to assist with the community, how to provide aid to the community, mutual aid. Again, Ms. Martin, like all the other individuals, she has strong ties to her own community, and while Ms. Martin also has aspirations of going to law school, clearly fleeing and failing to appear at trial, or things that would certainly be a hindrance to that. And so, Your Honor, we would just ask for a reasonable bond.
All right. Thank you. Mr. Johnson, any response?
Nothing further, Judge.
All right. So at this point, I do find she is similarly situated to the others. Maybe just came a day before, has ties outside of the state. So at this stage, I am going to deny based on a flight risk and a threat to the community, property, and persons. Y'all may file a bond motion before Superior Court and be heard there, and that's the court that will have the case. And we will schedule the hearing, a preliminary hearing in the meantime. All right? Thank you. And you may follow the direction of the deputies. Okay, I'm just going to keep going with these so we can get through the co-defendants. The next person I have is Kaylee Meissner. All right. Good afternoon. Ms. Meissner, you were charged in warrant number 23W003599. Mr. Bennett, have you had a chance to go over the charge with your client?
Yes, Your Honor, and for the purpose of this hearing, we will waive formal reading of the arrest warrant.
All right, thank you. Your attorney indicates that he is waiving a formal reading of the charge into the record. Do you understand the charge against you, ma'am? Yes. Thank you. What is the state's position on bond, and would you like me to know?
Yes, Your Honor. The state would oppose the granting of bond for this defendant. The facts contained within the affidavit of the warrant the court is familiar with. And this is one of the defendants that, in addition to those, has the additional fact that she was in possession of a shield. I would also point out that this defendant shows a address of Madison, Wisconsin, but I believe she also had potentially an ID from Massachusetts as well. I'm not sure if she lived there at some point. We're still very early on, obviously, in this situation. The point, though, is I have no evidence that she has any ties to this area. And so we would recommend that bond be denied and that be based on a threat to the community and that she is a flight risk.
All right. Mr. Bennett, what would you like me to know about your client?
Your Honor, I understand the court's primarily looking for something that distinguishes this defendant from the other ones who are similarly situated. I don't have a whole lot to say in that regard other than her age, which is 19. Obviously, no prior criminal arrest history, although there have been several other individuals with no criminal arrest history. Let's see if there's anything else. I guess for my client's edification, I do want her to be aware that I am aware of her medication issues, and I will ensure that the DeKalb County Sheriff's Office has her evaluated and taken care of as soon as I possibly can. I understand that's not necessarily a reason for granting bond in this case for that reason alone. But, just overall, Judge, we think that she meets the IALA factor, same as the other folks that came before.
I understand. Anything else, Mr. Johnson?
No, Judge.
All right. Again, based on the totality of the circumstances and the allegations involved surrounding the arrest and the lack of ties to this community, I am going to deny at this stage, finding that there's a risk of flight and a threat to the community, persons, and property. We will schedule your case for a preliminary hearing in the meantime, and your attorney will likely be filing a motion for bond in Superior Court, and he will talk with you about that. All right, ma'am. So if you just please follow the direction of the deputies. Okay, and the next person I have is Arrett William Nottingham.
Commissioner Bennett on behalf of Mr. Nottingham, Your Honor.
I'm sorry. Oh, thank you. I heard, okay. So Arrett William Nottingham, you are charged with warrant number 23W003587 with one warrant of domestic terrorism under the same case number as the others. Do you need me to read the warrant, or have you had a chance to go over the charge with your client?
Your Honor, we'll wait for formal reading of the warrant. And
All right. Thank you. All right, so your attorney indicates that you have had a chance to go over the charges and they're waiving a formal reading of the charge. So do you understand the charge against you?
Affirmative, Your Honor.
Thank you. All right, state, what would you like me to know on bond and what is your position on bond?
Yes, Your Honor. This defendant is similarly situated as the other defendants with the facts contained within the warrant, and also was another one that the fact is included that was in possession of a shield in addition to the muddy clothing and the breaching the embankment. Also, this is another defendant who is not from the area. This defendant is from Fort Collins, Colorado. And based on all of those things, we would request that you deny bond based on a flight risk and a threat to the community.
All right, what would the defense like me to know on bond?
Your Honor, before we get started, is there Ms. Harley Kennedy or Dawn Nottingham or Melissa St. Clair in the waiting room?
Hold on, let me make it bigger. I see an Aubrey, a Carl Williams, and 11 Greenstones, Joy Wonder.
Okay, they may just be viewing on live during on YouTube.
I see a Huska and a Clark.
No.
Okay.
But Your Honor, in terms of Mr. Nottingham, I first like to clarify something. He was not one of the individuals that was caught with a shield. He in fact was wearing bright colored clothing. He had, if I'm not mistaken, a red sweatshirt on. And I think that we pretty much classify everybody into, two groups: either they're legally observing or they're domestic terrorists. And I think that we gotta take into consideration that there are some people that were just there as civilians engaging in, constitutionally protected behavior. You can actually go to a concert if you like, if it's in the park or whatnot. In terms of Mr. Nottingham, he's 22 years old. He is from Fort Collins, Colorado. And in relation to whether or not he has ties to DeKalb County, I think that most people don't have ties to a place where they come for a concert. A lot of these people are coming down for a concert and also coming down to engage in community work. And so the idea that they are, not going to return to court because they don't have ties to the community, I think is somewhat of a stretch. But I understand Your Honor taking that into consideration. I'd also like to add that Mr. Nottingham is a high school graduate. He graduated from high school and went into the ministry. He has served as a pastoral intern at his church. He's also an Eagle Scout in Colorado. He has absolutely no problem with staying away from any of the code amendments anybody listed. He has no problem with staying away from the incident location. Doesn't even have a problem with staying out of the state of Georgia, unless he needs to return to court. Now, I'm not sure if this is an option. I've seen it done before. My client, Mr. Nottingham, is also willing to be placed on an ankle monitor. If somebody that he needs to be placed on an ankle monitor to be able to ensure that he's not in DeKalb County and that he's not anywhere near this area. I'm not sure if that can be arranged, but Your Honor, I certainly be, get in contact with any of the ankle monitor companies here or in Colorado to arrange that. As I said, Mr. Nottingham was not. He didn't have any metal shields. He wasn't wearing camouflage. He's not wearing dark colored clothing. Any of these things that are listed about this group of people. And so I asked Your Honor also in terms of the blood, if there is anything in relation to Mr. Nottingham having blood on him. He didn't have blood on him until he was tased by law enforcement and face planted in blood. So that would account for the reason that Mr. Nottingham would have had blood on his clothing. Other than that, Your Honor, I understand that everybody seems similarly situated because everybody's been grouped into the 50 to 100 people that Criminal Church has on the Mark land. But as you know, there way more than 100 people there, so we also got to take account for who these other people were, what group do these other people fall. And I would argue that I wouldn't go as far as saying that Nottingham was legal observer, but I certainly wouldn't go as far as say that he was either that terrorist or was engaged in any of the behavior that is alleged in the affidavit. And so, Your Honor, we asked that, I believe it was one of the attorneys, I don't know if it was DA's office that spoke earlier about a former group of protesters that were given like a $10,000 bond. And so we asked that if Your Honor is so inclined to grant Mr. Nottingham a bond, we would ask for that $10,000 bond. He has absolutely no problem with staying out of the state of Georgia. If Your Honor would like, he would be willing to sign up and pay for an ankle monitor. I've been in contact with his partner, Ms. Kennedy, whom he lives with in Colorado. I've also been in contact with his mom, Ms. Nottingham, and Ms. Nottingham said that she can have him out of the state of Georgia within 24 hours. Immediately upon release, she will have a ticket for him to be out of the state of Georgia. And so, Your Honor, I asked that, and I'm not insinuating that Your Honor has not, but I would ask that you view Ms. Nottingham, Mr. Nottingham, as an individual in relation to these IAO factors and how they are applied to him or how they do not apply to him, and grant him a bond so that he can return back to Colorado.
Mr. Johnson, any response?
Yes, Your Honor. Just simply that, again, I don't have all of the facts at this stage, and we're not here to debate back and forth, but I did want to point out that it's my understanding at this stage that the reason that this individual was tased is because he resisted arrest and attempted to strike a police officer. And that's what happened. So that is not consistent with someone who is merely trying to attend a concert. There were many individuals there who were told leave, and they were given the opportunity to leave, and they did. You know, I think what gets lost here, and I don't think it's lost on the court, but I think it gets lost on people, is there's protest and then there's criminal acts. And the reason we're here today is because of people committing criminal acts, not protesting. And so we would recommend or request, Your Honor, that you deny bond, as this individual is a threat to the community and a flight risk.
Okay.
Your Honor, if I may, just a brief rebuttal.
Yes.
In terms of Mr. Nottingham running away, resisting arrest, I disagree with that. Mr. Nottingham was actually running because he was afraid, and I believe that there is some evidence that will show that that was the case. And again, Your Honor, I do believe that there's a difference between protesting and people that are committing violent acts. But I think that when we have these types of situations in our community, that things do sometimes get out of hand, and that law enforcement may not have the wherewithal to be able to determine who's doing what. But I think that, you know, when individuals have an opportunity to come before the court, that's the opportunity for the judges or counsel to be able to distinguish, you know, who is who. And I don't think that Mr. Nottingham falls into that group of domestic terrorism or terrorists or someone that was engaged in that sort of behavior. And so again, Your Honor, I just reiterate that, you know, like I said, Mr. Nottingham is willing to abide by any conditions, he's willing to go on ankle monitor, anything that Your Honor orders, and to go back home immediately, even if you're willing to want to banish him from Georgia, he's okay with that as well.
I understand. Let me just say, I'm not determined. He's before me charged with domestic terrorism for participating in this. That's the charges before me. Whether he was tased or not, what shirt he was wearing, that's going to be evidence down the road. But based on his ties to other communities and his alleged, the circumstances and the totality of the circumstances surrounding the charges before me at this time, I'm going to deny bond. He's a flight risk and a threat to the community and property. Now, the future court, we file a bond modification, and those options you presented may be options at that bond hearing. But at this time, I'm going to deny bond on those bases. All right. Thank you. I appreciate it. Do you have any other cases?
No, ma'am, be excused.
You may. Thank you. Sir, your attorney will get with you about any future bond motions, and you will be scheduled for a preliminary hearing in the meantime. Thank you. Okay, next we have Alexis Papali. All right, good afternoon. You're charged in the same case number in warrant number 23W003594 with 1 count of domestic terrorism. Have you had a chance to go over the warrant with your client?
Yes, we've had a chance to discuss the warrant and we will waive reading the charge.
All right, thank you. So your attorney has waived a formal reading of your warrant into the record. Do you understand what you're charged with?
Yes, ma'am, I understand the wording of the charge.
Thank you. All right, what is the state's position on bond and what would you like me to know in this case?
Yes, Your Honor. The state would oppose the granting of bond for this defendant. The facts are similar to all the other defendants we've heard in this similar situation. And this is also a defendant who was, according to the warrant, in possession of a shield. This defendant is from Massachusetts and has no appreciable ties to the greater Atlanta community. And so based on all of that, Judge, we would request that you deny bond as this defendant is a threat to the community and a flight risk.
All right. And I do show some criminal cycles were provided to me out of Massachusetts and California on this case. So I will hear from you, Mr. Who, oh, there we are. Yes. So I will hear from defense counsel at this point.
All right, thank you, Your Honor. Well, I do need to mention that, well, several things about him. Alexis Polly, right? Sorry, sir. He had a flight planned for Monday to head home to Boston to see his daughter. And he was here for the weekend in order to enjoy the music festival and the protest. When I look at this warrant, I'm deeply concerned at the generic nature of it. It's clearly a cut and paste copy. And the problem I have with that, of course, is what Chicago said best, and that is basically we've got a situation here where all these people are being declared guilty by association, or they're accused by association. And that's deeply problematic. This is a flimsy probable cause at best. And frankly, this is a safe way of punishing people who oppose the militarization of the police. I want to mention that a couple other things about him. Nothing in this warrant says he was in possession of any weapons. They keep talking about a shield. That shield is not a weapon, and I think it's important that people understand that. Moreover, that's the allegation on the warrant that he had a shield. This is an example of why cutting and pasting warrant allegations is a problem, because he did not have a shield in his possession. He had drumsticks. It was a noise-making device. It's a way to exercise your First Amendment right. So I think the things that he had on are evidence that he was there to protest, not to cause any sort of havoc. And to the extent that the court wants to believe the allegation that he had a shield on him, again, that's a defensive thing, not an offensive thing. I'll also add that we have a character witness. Oh, yes. Let me quickly mention his title. He is the Director of Regional Economies for the Center of Economic Democracy. This is a policy think tank that is focused on protecting people's rights, among other things. And so it's part of his job to come down and protest in places. That being said, I would like to call somebody on his behalf, a character witness, and that would be Carlton E. Williams, if Mr. Williams is in the Zoom call still. I know we've been your name.
We will bring that person in.
Thank you, Your Honor.
All right, sir, can you see and hear us?
Yes.
Okay. All right. Counsel, you may swear your witness in and ask him any questions.
Hello, Mr. Williams. Do you swear or affirm to tell the whole truth and nothing but the truth under penalty of perjury?
I do.
Thank you, Mr. Williams. Mr. Williams, can you quickly tell us what your title is, where you work, a little bit of background about who you are, so that the court can understand why you're a credible witness?
Certainly. My name is Carlton Williams.
I'm a professor of law at Cornell University. I'm at Cornell right now. I reside in Boston, so I do a little bit of traveling. I'm a barred attorney in Massachusetts and in some federal courts, the district court and the circuit court of appeals in Massachusetts.
Okay, thank you, Carlton. How long have you known, may I call you Carlton, by the way? Or Mr. Williams, I'll call you Mr. Williams, sorry about that. So the question I would have for you is how long have you known Mr. Polly?
I was trying to think of the exact date. I think it's, I've known Alex Papali since 1999. So 20, whatever that is, that's math, 24 years, I believe. Well over 2 decades I've known Alex.
Are you guys friends?
Friends, colleagues. I've worked on some projects with Alex. I've worked on some events with Alex and numerous things.
Okay, and what would you like the court to know today about like Alex's character?
So just as I said, Alex is a friend of mine. He's a colleague of mine. He's also at times been a neighbor of mine. He's a neighbor of mine currently. He's like a brother to me. I hope he thinks the same. I know that he's a very trustworthy and reliable person. I know his daughter and the mother of the child. His daughter is just, I think, turning 10 now. And I'll just say, just a bit of a story about Alex. Alex frequently puts together potluck dinners in the community, in our community in Boston, and brings many different people together from sort of different walks of life. And I've many long-lasting friendships from those dinners. I also know that many of those people are on the live feed right now. I've probably been contacted by a couple dozen, if not more people, since yesterday, some at very late hours of the night. So Alex has an enormous amount of support in the Boston community, and I'll say across the country. Someone just contacted me this morning from Chicago, trying to support Alex. And I'll just say this. So I'm a criminal defense attorney. I was a longtime public defender in Massachusetts. And I've represented thousands of people. I've taught thousands of students. I can say absolutely assuredly, and it's something I've never said in court before, and I've never said before a judge before. I can assure the court that Alex is going to return to court. I know that for a fact. And I can assure the court that he's not a danger to the community here in Massachusetts or in Georgia. And that isn't something, I was actually nervous about saying that. It's not something I say lightly, but it is something I want to say. Alex will return to court. He will fight these charges. And he isn't a threat in any way, in my opinion.
Let me ask you another question. Is he, do you think he's intimidating and that he might intimidate witnesses?
No, I mean, I should have said it also. I think I'm sure that Alex would follow, any of the court's orders in terms of reporting or in terms of staying away from other witnesses in this matter or any witnesses or co-defendants.
Okay, thank you, Mr. Williams, for your comments. I have nothing further for.
Thank you. Thank you, Your Honor.
Mr. Johnson, any questions?
Just a couple real briefly. Sir, good afternoon. Did the defendant, Mr. Papali, share with you that he was coming to Atlanta for this event?
I didn't know. I probably would have. I actually traveled. I was at a conference in Eugene, Oregon, and then back to Ithaca. So it's been about 3 days since I've been to Boston. I didn't know that he was going to Atlanta.
Okay, thank you. That's all I had, Judge.
But I'll just say one more thing. He's frequently, I mean, the last time I saw Alex, he just rang my doorbell, which people rarely do anymore. And he came over my house and we spoke at length. But we speak very regularly. I see him biking around my neighborhood pretty frequently. So, but it's my fault, not his, that we haven't been in contact in the last week.
Of course. Thank you, sir.
Thank you.
My client says hello, Mr. Williams, and thank you for your time.
All right. Thank you, sir. You may be excused. I appreciate it. All right. Anything else from the defense?
I just want to reiterate that we have a daughter at home that he needs to go see. I fully believe that he also would come back. I mean, but that's based on what the evidence that you have seen now. So that being said, please take into consideration that we have children to take care of here. Thank you, Your Honor.
Mr. Johnson, anything else?
No, Your Honor. We just oppose bond, and I have nothing.
Okay. I do feel and am empathetic towards families and children. Unfortunately, lots of people who come through the arrest process have families and children. And so I do hate to see that. But again, you know, no, everyone's saying they weren't there to do anything, which is their right. Everyone's saying they got caught up. I have 23 people before me that were detained and with the charges that are in front of me. And that's what I'm going on. The evidence down the road, what that will be seen at a later date. But based on the charges before me and the lack of ties to this community, I'm going to deny bond. Based on a risk of flight and lack of threat to the community, persons, and property. And we will schedule your case for a preliminary hearing in the meantime. And your attorney will get with you on filing a motion for bond before Superior Court, who will have your case. All right. Thank you. I appreciate it. And please follow the direction of the deputies.
Thank you, Your Honor.
Okay. Next, we have Mr. Cameron Daryl Peeps or Peepes or Pipes.
Pipes, Your Honor.
All right, good afternoon. You are charged in the same case number. Warrant number 23W003588 is your warrant number. Have you had a chance to go over the charges with your witness or with your defendant, sir?
Yes, Your Honor, and we'll wait.
All right, thank you. So, Mr. Pipes, your attorney has indicated that they're waiving a formal reading of the charge into the record. Do you understand the charge against you?
Yes, Your Honor.
Thank you. All right, what does the state like me to know on bond and what are you requesting?
Your Honor, the state would oppose the granting of bond. Mr. Pipes is similarly situated to the other defendants based on the information contained in the affidavit. And this defendant is also from out of state, showing a home of Baton Rouge, Louisiana, and has no ties to this community whatsoever. And we would request that you deny bond because he is a flight risk and a threat to the community.
All right. What would the defense counsel like me to know about bond in this case?
Your Honor, I don't think my client is a threat to the community. He's never been arrested before, never been in trouble with law. Also, as far as the ties to the community, my client lives in Clarksville, Tennessee. And his friends are mostly from there. He works at the factory, dealing with steel wires in Clarksville, Tennessee. He's worked there since September of 22. You know, if he's going to be continuing to be incarcerated, he's going to lose his job and, you know, possibly get evicted from his apartment that, you know, he has a lease there that goes through August 23. I just happened to check, you know, how far Clarksville, Tennessee is from here, and it's closer than Brunswick, Georgia. But I think reading that the state border sort of makes an actual difference in the formalistic interpretation of this, you know, tie to the community standard. If I may argue that. My client is being much like, you know, others before him, haven't been engaged in any of the events that were succeeded before. In fact, this is my client's first protest in his life that he's been to or could argue would be associated with, I guess we'll say that. And I'm here for this week of action. We go with the minutes of the concert and here. That's all I have to say, Ron.
All right, thank you. Mr. Johnson, anything else?
No, Your Honor.
Okay. So while he is in a closer state, he is still in a different state than the one our community is located in. So at this point, at this stage, I am going to find that based on similarly situated to the others, based on the allegations in the warrant and the circumstances, totality of the circumstances, I'm going to find that he is a threat to the community, persons, and property, as well as a risk of flight or not returning to court. So I'm going to deny bond at this time. Similar to the others, your case will be set down, scheduled for a preliminary hearing, and your attorney will file a motion for bond for you to be heard in the Superior Court. All right? Thank you, sir, and please follow the direction of the deputies.
Thank you.
All right. Next, I have Victor Puertas.
Your Honor, I'm here on behalf of Mr. Puertas this afternoon.
Thank you. Mr. Puertas, your warrant number is 23W003582, and you are charged in the same case number as your co-defendants with 1 count of domestic terrorism. Mr. Bennett, have you had a chance to go over the charges with your client?
We have discussed the charges and the facts incident to his arrest, Your Honor, and we will waive formal reading of the warrant at this time.
All right, thank you. So, sir, your attorney is indicating that he's going to waive a formal reading of the charges into the record. Do you understand the charge against you, sir?
Yes, Your Honor.
Thank you. All right, I will hear from the state on bond and then from the defense.
Yes, Your Honor. The state would oppose the granting of bond for Mr. Puertas. He is similarly situated to the other defendants based on the facts contained within the affidavit. Also, like almost all of the other defendants, he is from out of state, showing a home of Provo, Utah. And based on those facts, we would request that you deny bond as he is a flight risk and a threat to the community.
All right, and I was provided with criminal histories from 3 states other than Georgia, where the defendant may have had ties. So I will hear from defense counsel, Mr. Bennett. What would you like me to know on behalf of your client?
Yes, ma'am. Briefly, the arrests in question that's before the court, they have all been resolved through deferred adjudication. They're all civil disobedience related and activism related arrests, and none of them are convictions. Mr. Puertas, from my understanding, is an environmental rights activist. He is indigenous activist. He works in indigenous communities across the United States. I have several character letters from people who are close to him and have worked with him on these issues in the past. He's a valuable member of whatever community he's in, has been the resounding information I've received from pretty much everybody I've talked to about Mr. Puertas. Your Honor, similar to everyone else, we feel like he's a good candidate for bond. He meets the Ayala factors. My understanding, and again, just as counsel said previously, is a very early stage of the case, and we're still all getting our facts straight. We're trying to get as much information as we can from many different sources as we can. But from my understanding is, I think the reason why Mr. Puertas is here is because he ran. And I think the reason why he ran was, of course, like some of the other individuals, he had a great deal of fear of confronting law enforcement. The way that they came in was very aggressive. They were armed to bear. They were wearing flak jackets, guns pointed. There was a lot of threat of violence inherent to that. So even one of the officers even said, why'd you run, man? You shouldn't have run. We wouldn't have tased you. He was tased. He was struck in the face. He was put in a chokehold. So he had a real tough time of it. And sometimes it's better to just surrender and you're under arrest, but you'll be released. I don't think there's going to be any evidence showing Mr. Puertas was involved in any of the vandalism. He was here for an absolutely legitimate purpose, a First Amendment protected purpose. And for those reasons, among others, we think that he is a good candidate for bond. And there are conditions the court could impose on him that would be sufficient under these circumstances to guarantee his appearance in court and his, compliance with legal process, Your Honor.
All right. Mr. Johnson, any response?
Just very briefly, Judge, just to point out that the police didn't engage with the crowd at the concert till the crowd at the concert engaged with them. So, when I hear things about one of the other attorneys saying the militarization of the police and, this defendant was just scared and running because the police came in aggressively, this all started because of the individuals that are here right now. They breached a locked fenced area, broke into it, destroyed property, and attacked the police such that they had to retreat. You can see it in the video. So, you know, if everybody had just stayed at the concert, maybe nothing would have happened. Maybe they would have gotten criminal trespass warrants. I don't know. So none of that is really what I hear from some of the defense attorneys. I think something that the court should take into consideration. Of course, you should hear everything, but we would request that you deny bond for this defendant.
Again, I'm not here. I have the charges before me. How they play out is not before me, but I have to make a decision based on the charges before me, which are a bit more extreme than the others, which is why I'm making the decisions that I'm making. And whether something is a peaceful or a constitutionally protected right of protest, or whether it has crossed the line into the allegations of aggravated assault on law enforcement is not before me right now. And so based on that, at this point, I do find him similarly situated or with ties to multiple other states. And so I'm going to deny bond based on the risk of flight and a threat to persons, property, and the community here. And so y'all may file a bond motion before Superior Court, and you will be scheduled and heard there, and we will schedule your preliminary hearing in the meantime.
Yes, ma'am. And for my client's edification, that bond motion should have been filed shortly, just a few minutes ago. So,
okay. Thank you.
And thank you for your consideration, Judge, on all these matters, and thank you to the Public Defender's Office for bearing with this process.
For waiting.
So sorry.
All right.
And,
no, it's all right. Do you have any other cases before us today?
No, ma'am. And I was going to ask to be excused at this time as well.
You may be. Thank you, Mr. Bennett. I appreciate it. Okay. So I understand which one of ours requires the language line. Is that the Frederick Robert Paul?
Judge, I believe that's Dimitri Lenny.
Okay, so let's go ahead and do Robert Paul. And then we may have to do language line cases last after I take the public defender's couple of cases. So just please hang in with us on that. All right. Good afternoon. You are charged in same case number as the others, 10-0277-25-22 with one warrant number 23W003590, domestic terrorism. And I see your attorney is next to you. Have you had a chance to go over the charge with her in this case?
Good afternoon, Judge. This is Sabrina Hassanali. I'm associated with Matt Bass. We did take a look at the warrant and went over the charges there.
Okay, and I'm sorry, I didn't catch the last part. Are y'all waiving a formal reading of the charges?
We are waiving a formal reading of the charges.
Okay, thank you. Ma'am, your attorney indicates that they are waiving a formal reading of the charges, and they have gone over those themselves. And so do you understand the charge against you, ma'am?
Yes, Judge.
Thank you. What would the state like me to know about bond in this case, and what are you asking for?
Yes, Judge. The state would request that bond be denied for this defendant. The facts contained within the affidavit are similar to the other defendants you've heard us talking about, and that this particular defendant is also not from here and not from this country. She's actually from Canada. And so based on those things, we would request that you deny bond, as she is a flight risk and a threat to the community.
All right, thank you. And what would you like me to know about your client, ma'am?
Good afternoon, Your Honor. Let me go over a few things. In terms of how this client is distinguished from the other defendants, the fact that she's Canadian is actually weighs heavily in her favor because denial of bond in her case is punitive. Because there are criminal and legal consequences for a charge or even being caught up in this process, she may be actually legally barred from returning to the state. So what I would argue that the best case here is with Cecil. Let me tell you a little bit about this Robert Paul. She's 34 years old. She lives in Quebec. She has family there. She owns property in Quebec. She has no criminal history. She's an electrician, and she actually has a return ticket to Quebec. On Sunday, Saturday, even sooner. So she's eager to return. In fact, she has classes on Monday. And so a denial of bond for her would be doubly punitive because she would be denied, the licensure that she has earned, electrician, to, she wouldn't be able to pursue her continuing education and would be, barred from working there. So, in addition to that, she has no criminal history. She actually was down here for the weekend to visit a friend who is sick. And they decided to take advantage of the nice weather and go out and camp. This defendant is like 110 pounds. She has, is not intimidating, is not looking to create any problems, and is happy to agree to staying away and having no contact with other defendants. So I'd like to ask for at least, at the very minimum, an unsupervised bond, or the best case scenario would be best for just to have this whole matter dismissed.
All right, so I don't think I am in the position to be able to dismiss any charges at this point. I don't have the authority to do that at this point, and that's not what this hearing is for. Mr. Johnson, do you have a response?
No, Judge, I stand on what I stated to the court earlier and would still request that bond be denied for this defendant.
I'd like to chime in if I may.
Who said that? The
attorney.
Okay, I couldn't tell. Okay, go ahead. What did you want to say?
I want to just add that this defendant was actually on her way out of the forest. So in my discussion with her, she had already packed her lunch, she was already camped and like got her things together. So the kind of allegations in this warrant really don't apply to her. She was not carrying a shield. She was not attacking anybody. She was actually in the process of leaving the forest. She did not want to get entangled with the whole foreign legal system. So for those reasons, we at least ask for her to be out on bond.
Okay, thank you. Again, I just have the charges that are before me. The weight of evidence and whether the charges will be proven down the road are not a question for me at this point. I am going to deny bond because she is a flight risk, being a citizen of another country and a threat to the community and property here. Also, people get arrested who are not citizens of the United States every day, and it is not a ground for dismissing charges against them. So I understand she has a tough situation, and I hope that you as her attorney can help her with that. But at this point, I'm going to deny bond at this stage, and y'all can have a bond hearing in Superior Court and file a motion for bond there, and we will set the case down for a preliminary hearing in the meantime. Okay, thank you, ma'am.
Thank you.
Okay. All right, I'm going to go to Samuel Ward. Is that our last one that is not language line?
That's correct, Your Honor.
Case?
Yes.
Okay. All right, so let me go to Mr. Samuel Ward. Good afternoon, sir. You are charged in case number 10-0277-25-22 with one warrant, 23W003597, domestic terrorism, same as the co-defendants that have gone before you. Have y'all had a chance to go over the warrant and charges with your client?
I have, Your Honor, and I do not waive a formal reading of the charges.
Okay, well, thank you. I will read them for you. Just one moment. Okay. Okay, it has come up now. All right. Let me make sure I have the right number. Okay, Mr. Ward, you are charged in warrant number 23W003597. The warrant alleges at that address on Key Road on March 5th of 2023, between 2 p.m. and 8 p.m., you did attempt to commit a felony violation of the laws of this state, which as part of a single unlawful act or a series of unlawful acts which are interrelated by distinguishing characteristics, is intended to cause serious bodily harm, kill any individual or group of individuals, or disable or destroy critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss and is intended to change public policy. To wit, said accused was a member of a group of approximately 50 to 100 people that criminally trespassed on marked land, walked approximately half a mile in the forest, and began to assault police department officers, Atlanta Police Department officers, and Georgia State Patrol troopers with rocks, fireworks, and Molotov cocktails, placing the officers and troopers at a risk of receiving serious injury or death. Multiple pieces of heavy machinery. Hold on, my screen just disappeared. Multiple pieces of heavy machinery were set on fire. Much of the group was also equipped with homemade metal shields and wore camouflaged or dark colored clothing. Many of the above actions were publicly posted on the group's social media accounts, and the chant "Stop Cop City" was repeatedly used. So that is the charge against you, sir. Do you understand the charge against you?
Yes, Your Honor.
Thank you. All right. I will hear from the state and their position on bond and their request in this case.
Yes, Your Honor. The state would oppose the granting of bond for this defendant. This defendant is similarly situated to the other defendants based on the affidavit and the warrant. Also, he is not from this area. I show that he is from Mesa, Arizona, but I also have a prior arrest for him that was from Tennessee. So between those two things, we would say that he is a flight risk and a threat to the community, and we would request that you deny bond.
All right. Thank you. And what would the defense like me to know about your client and bond in this case?
Yes, Your Honor, there's a couple of things I want to mention. The prior arrest in Tennessee was a misdemeanor charge, and my client did community service, which I believe demonstrates that he will comply with court orders, including one that would be for him to show up for a trial. The second thing I want to say is I had to read the affidavit that allows, so of course my client could hear it, but I also wanted you to notice there's nothing specific in the affidavit whatsoever about my client, not what he was wearing, not where he was. This is quite literally the most cut and paste version I've seen of this. There's literally no specific allegations about him. So I'm deeply disturbed by that. How can we prepare for his defense? We don't even know. And I recognize evidence supposedly, but I'm not sure they have any evidence because frankly, there's no specific allegation. We don't even know why they think they arrested him. They're literally, in this case, saying that he may be guilty because he was in that general area. There were close to 1,000 people there. I mean, this is, 50 to 100 people were involved in allegedly in the acts that happened on Key Road. I'll mention also that he was arrested in the Radio Flyer Bar, which is located on Constitution Lakes Road and on West Lake Avenue. So this is literally the completely other side of the woods. He had nothing in his possession. There's no allegations about that in here, but he had no sort of weapon in his possession. What he had in his possession was a beer. He was enjoying a concert, drinking a beer when he got arrested. Your Honor, I've had people call on his behalf. They had to unfortunately go because of this hearing. Talk about that in a moment. Let's talk about why he was even here. My client lives in Mesa, Arizona, and he came to Tennessee to visit his mother and sister. And while he was there, his friends were like, "Hey, we're going to Atlanta for a music concert." So that's why he came here. His complete plan was to leave the day afterwards. So, following. I know you're looking only at the layout factors here. But I do not see why it would be a significant risk of flight. Stated to do that by the ponderance of the evidence. Additionally, I don't see how it could be a significant risk to danger to persons or property in the community. There's no allegation in the affidavit that he was involved in the things that were destroyed. There's no evidence, nothing in the affidavit to suggest that he's a significant risk of committing any felony in the trial. He certainly wouldn't commit it here in this state because his plan is to go home and see his partner in the state of Arizona. So at the end of the day, I find nothing about him intimidating, and the only possible people that could be intimidated would be police, who are certainly not intimidated by any of these souls. So when I'm looking at these factors here, I don't see how the data shows by the ponderance of the evidence any of these things. At the end of the day, I would ask that he be granted. Obviously, I want the charge to be dismissed. I recognize you're not going to do that today. So I would ask for a signature on it. Or in the alternative, reasonable conditions, and he's obviously willing to comply with, any court conditions about not being in the, area of Cuba, et cetera, et cetera. Thank you, Your Honor.
Thank you. Mr. Johnson, any response?
No, Your Honor. I stand on my prior argument.
Okay, I find that he is similarly situated. There has been no showing that he has any ties to this community. And so I find there is, at this stage, a flight risk. And it's not just returning to court, it's whether there will be an ongoing threat to the person's property and community where we are in this county. And so I find there is a risk based on the totality of the circumstances in this allegations of the warrant. So at this time, I'm going to deny bond, but y'all may file a bond motion before Superior Court and be heard there. And we will schedule your case for a preliminary hearing in the meantime. All right. Thank you very much.
Thank you, Your Honor.
Okay. I have one question. Mr. Bass, you still there? So I have a case, and I'm not calling this case yet, but are you representing Aubrey Vilines?
I am not, Your Honor. That was an error and that needs to be corrected. I just haven't had a chance to do that.
Okay, so did the public defenders hear that?
Yes, Your Honor, I would have to call and speak to her then.
Okay, so let's see. We have a language line, and then we have number 5. Who represents? We already did Jamari Brown. Who represents Mr. Ramirez?
Your Honor, our niece Cabrera Alvarez on behalf of Mr. Ramirez.
Okay. And Ms. Henris, let's see, number Duarto is also a language line.
Judge, that case will actually be reset. I don't believe we've been able to secure a Mano translator, and we're going to attempt tomorrow to get it fixed for him to have a hearing.
Okay, and we can maybe have one in person that can.
Judge, his brother has said he would interpret for him, at least so we could interpret to him, and then if we could get a consent, kind of work that out beforehand, hopefully, to make it a little bit easier.
Okay, so I will note that number 9 is a reset with potential. Y'all will talk later on that. So Mr. Ramirez is Ms. Cabrera Alvarez, and then and who is Mr. Jackson?
He's my only other case, Judge.
Okay. Well, then I guess I'll let you go ahead and make a call and we'll adjust as needed, okay?
Okay, thank you.
Thank you.
Can the jail, is it the same number that was in the chat earlier?
Yes, ma'am.
I'll call right now. Thank you.
All right, thank you.
Your Honor, I know it may be extremely inconvenient since it is a language line case, but if there's any chance that we could do position 19 just so that Mr. Johnson can go ahead and leave. I believe that's his last case. I know he won't ask, but since he's my boss, I feel like I should ask.
Oh, you want to? Yeah, no, I know. I was just, we got a couple language lines. If y'all are okay with it, we can do that.
I was just going to say, Judge, I appreciate that. But I'm here at the court's pleasure, and as long as it takes, we'll get it done.
All right, let me ask, are they already calling the language line?
Yes, ma'am.
All right, I was gonna say, y'all can let me know what you would prefer to do, with the remaining cases. So this one, is French.
Before you say anything, please speak the name of the desired language.
French.
Understood. French. If this is correct, say yes.
Yes.
Please hold for the interpreter.
Thank you for calling Language Sound Solutions. This is Abu Bakari. My ID is 219-746. I will be your French interpreter today.
Thank you. Can you hear me and understand me all right? Can you hear and understand me?
Is the only way we can get closer to the phone because you feel like you're far away from the
Deputies, could y'all let me know if you can move it any closer?
Okay.
Okay, there we go. Can you, sir, this is Judge Davis from DeKalb County Magistrate Court. Can you hear and understand me all right now?
I can barely understand what you're saying, Your Honor.
Okay, well, we're gonna do our best and I'm gonna speak louder into the microphone to see if that can help, okay?
Okay.
Can you please raise your right hand for me so I can swear you in?
Yes.
Do you solemnly swear or affirm that you will truly correctly and faithfully interpret from English to French and French to English to the best of your ability under penalty of perjury?
Yes, I do.
Thank you. Could you please introduce yourself to our defendant who is before us? We are having a first appearance hearing and the defendant's name is, can y'all tell me what position she is on the calendar again?
I'm not sure what position, but the defendant's name is Dimitri Lenny.
Hold on, let me get the position on the calendar.
Position 19, Judge.
Perfect, thank you. And that's right, because Ms. Trin asked about position 19. All right, so could you please, Mr. Interpreter, introduce yourself to Dimitri Lenny and make sure she can hear and understand you?
Allô, bonjour. Allô, vous m'entendez? Dimitri Lenny. Je suis l'interprète. Je voudrais savoir si vous m'entendez, vous me comprenez aussi. Oui. Okay.
Thank you. So I have some initial announcements I need you to translate for me, please, sir. And I will start now. This is your first appearance hearing and is not the trial of your case.
Okay, ça c'est votre première audience. Ce ne sera pas pour décider votre dossier.
This is an informational hearing to make sure you understand what you are charged with, to advise you of your rights, and to consider bond in your case.
C'est juste une audience d'information, à titre d'information, pour que vous sachiez à quoi on vous accuse et aussi vous devez savoir vos droits et aussi si vous devez poser une caution.
I'm not here to take any pleas or determine whether you are guilty or not guilty.
Je ne suis pas là pour prendre votre plaidoyer, si vous êtes coupable ou non coupable.
Please understand this hearing is being broadcast over the internet while the proceeding is going on and is also being recorded by the court.
Sachez que pendant que nous sommes la procédure judiciaire est en cours, ça sera aussi enregistré au fil du temps.
So anything said could be used against you in later court proceedings.
Tout ce que vous pouvez dire, vous allez dire, peut être utilisé contre vous durant la procédure judiciaire successive.
In some cases, I cannot set bond or I might deny bond, but that does not mean you will never get a bond. It means you won't get a bond today from this court.
Je ne suis pas non plus en mesure de soit poser une caution pour vous, ou aussi de rejeter la caution pour vous. Par contre, cela ne veut pas dire que vous ne pouvez pas poser une caution, mais ce n'est pas aujourd'hui.
If that turns out to be the situation in your case, your attorney will follow up with you about filing a motion for bond to be heard in Superior Court.
Si ce sera le cas pour vous, et votre avocat va vous informer comment vous allez faire pour pouvoir porter la caution au tribunal supérieur.
Now I'm going to inform you of the rights you have in any criminal case.
Maintenant, je vais vous informer des droits que vous avez concernant le cas criminel.
You have the presumption of innocence unless and until the state proves the charges against you beyond a reasonable doubt at trial or until you enter a guilty plea.
Okay. Vous êtes censé être innocent jusqu'à ce que l'État puisse démontrer que vous êtes coupable au-delà des raisons, au-delà des cas raisonnables.
You have the right to a jury or a bench trial, and at that trial, the state has the burden to prove every charge against you beyond a reasonable doubt.
Vous avez aussi droit à un procès du jury ou bien à un procès judiciaire, d'accord? Et jusqu'à ce qu'on démontre vos accusations au-delà des trucs raisonnables.
You have the right to call your own witnesses at trial and to introduce your own evidence and to use the subpoena power of the court to do so.
Vous avez aussi le droit de fournir vos témoins et aussi vos preuves, d'accord, devant le tribunal. Et aussi utiliser tous vos pouvoirs, d'accord, d'injonction pour pouvoir l'obtenir.
You have the right to testify at trial, but it can be used against you, and you will be cross-examined by the state.
Vous avez aussi le droit de vous-même de témoigner pour votre cas qui peut être contre vous. Et on va aussi vous poser des questions à titre de ça. D'accord?
You also have the right to remain silent, and that silence cannot be used against you.
Vous avez aussi le droit de rester silencieux et ce silence ne pourra pas être utilisé contre vous.
You have the right to be represented by an attorney at trial, and if you cannot afford one, one will be appointed to represent you free of charge.
Vous avez aussi le droit d'être représenté par un avocat, et si vous n'avez pas de moyens d'en embaucher un, on pourra, l'État peut, le tribunal peut vous procurer un gratuitement.
You also have the right to a preliminary hearing where a judge will decide if there is sufficient evidence to support the charges against you.
Vous avez aussi droit à une audience préliminaire où le juge va décider s'il y a vraiment un cas des preuves suffisantes pour pouvoir vous accuser.
This will not be a hearing on your guilt or innocence, but just whether there was enough probable cause to arrest you, and you and your attorney will have an opportunity to examine the evidence.
I'm sorry, Joanna.
That's fine. This hearing will not be a hearing to determine your guilt or innocence, but just whether there was enough evidence to support the charges against you and arrest you.
Okay. Ce jugement, cette audience ne sera pas pour déterminer si vous êtes coupable ou si vous êtes innocent. C'est juste pour démontrer s'il y a fait des preuves pour pouvoir, justificatives pour pouvoir vous accuser.
The state will present evidence, and you and your attorney will have an opportunity to examine this evidence.
L'État va présenter ses preuves et vous et votre avocat, vous avez maintenant le droit de pouvoir vérifier ces preuves et présenter la vôtre.
If the judge finds sufficient probable cause, your case will be bound over to the district attorney's office, who may formally charge your case.
Si maintenant on trouve un motif raisonnable pour votre cas, et votre dossier sera orienté vers le procureur de district pour pouvoir présenter ces cas devant vous.
If you get out of jail on bond, you still have the right to be formally charged and the right to a trial by jury.
Si vous êtes libéré par caution, vous avez le droit aussi d'être accusé, et aussi vous avez aussi le droit d'avoir une audience, d'accord?
Once you have been formally charged, you will have an arraignment before a superior court judge where you can enter a plea and be sentenced, or enter a plea of not guilty and have a bench or jury trial date set in your case.
Si vous, au cas audience, on va présenter les doléances devant vous, d'accord? Et vous allez vous présenter devant le juge, où vous allez déclarer coupable ou non coupable. Et après là, on va décider comment procéder à votre cas.
If you are convicted of any felony offense, you may face a minimum of 1 year up to a maximum of life in prison, depending on the severity of your charge.
Si on vous trouve coupable, vous pouvez par exemple passer 1 année au minimum, ou bien la prison à vie. Dépend maintenant, ça dépend maintenant de la vraiment de l'éternité de votre cas qui est contre vous.
Some or all of that may be served on probation, again, depending on the specific charges.
Et vous pouvez aussi être juste on va aussi vous mettre en liberté, d'accord? Et surveiller jusqu'à ce que on se trouve pas.
If you are convicted at trial, you have the right to appeal that conviction.
Si on vous trouve coupable à l'accusation, vous avez aussi le droit de faire des recours.
All right. So ma'am, you are charged in case number 10-0277 2522.
Le cas qui est devant vous est le cas 10-02-77-25-26.
That is the same number as the case of your co-defendants.
I'm sorry.
That is the same number as the case of your co-defendants.
Ok, c'est aussi le même numéro que l'autre défenseur, le co-défenseur qui est avec vous.
Your warrant number specific to you is 23W003586.
Le numéro spécifique qui est désigné pour vous uniquement, c'est 23W003586.
It is one charge of domestic terrorism.
C'est une accusation d'un terrorisme domestique.
Madam Attorney, have you had a chance to go over the charge with your client?
We haven't had a chance to go over the arrest warrant. While we've spoken about the charge, I would like the arrest warrant to be read. So I'm not going to be waiting for.
Okay, so that's fine. Hold on, let the interpreter interpret. Okay, can you state that briefly one last time for the interpreter, and then I will read the warrant.
Yes, I'm not going to be waiving a formal reading of the charge.
Non, je ne peux pas faire la dérogation formelle de l'accusation.
All right. So I will read the warrant now, and Mr. Interpreter, if you could please interpret for me.
Ok. Je vais maintenant vous lire, d'accord, le mandat d'arrêt. On va vous le lire maintenant.
Said accused did attempt to commit a felony violation of the laws of this state.
L'accusé suivant a été tenté de commettre un crime en violation de la loi de l'État.
Which, as a part of a single unlawful act or a series of unlawful acts,
Que ce soit un acte unique ou bien un acte en série,
which are interrelated by distinguishing characteristics,
qui sont en fait liés en se basant sur les caractéristiques les caractéristiques qu'ils ont ensemble.
Is intended to cause serious bodily harm,
C'est dans l'intention de causer un mal corporel sérieux.
kill any individual or group of individuals,
Deuxièmement, un individu ou un autre individu.
or disable or destroy critical infrastructure,
Ou un infirme, ou dans le but de détruire des infrastructures critiques.
a state or government facility, or a public transportation system,
À un État ou bien à une enceinte publique ou bien à un transport public.
when such disability or destruction results in major economic loss,
Cette incapacité est aussi, cet acte va aussi causer une perte énorme économique.
and is intended to change public policy.
C'est pour dans l'intention de changer la police publique, la politique publique.
To wit, said accused was a member of a group
Pour ça, lorsqu'un membre d'un groupe
of approximately 50 to 100 people that criminally trespassed
d'un groupe à peu près 50 à 150 personnes qui ont fait dépasser le lac criminel
on marked land,
I'm sorry, Your Honor,
on marked land
sur la ligne de marche,
walked approximately half a mile in the forest
et approximativement une kilomètre vraiment de la forêt.
and began to assault Atlanta Police Department officers and Georgia State Patrol troopers.
Et a commencé à agresser l'officier public
With rocks, fireworks, and Molotov cocktails.
avec, par exemple, du cocktail Molotov et aussi avec des armes.
Placing the officers and troopers at risk of receiving serious injury or death.
En mettant en exergue l'officier et aussi le groupe à peut-être une blessure corporelle énorme.
Multiple pieces of heavy machinery were set on fire.
Plusieurs, par exemple, machines et aussi plusieurs choses ont été mises aussi ont été incendiées.
Much of the group was also equipped with homemade metal shields.
Un membre du groupe a aussi utilisé, par exemple, un vieil métal, en métal,
And wore camouflaged or dark colored clothing.
avec, par exemple, les habits sombres, ou bien ils ont été en camouflage.
Many of the above actions were publicly posted on the group's social media accounts.
Or, toutes ces actions ont été aussi postées sur, par exemple, les médias publics sociaux.
And the chant "Stop Cop City" was repeatedly used. And the chant "Stop Cop City" was repeatedly used.
Et le texte Stop City a été utilisé à répétition.
All right. So, ma'am, do you understand the charge against you?
Madame, vous comprenez les accusations de mort?
Oui.
Yes.
Thank you. At this point, I will hear from the state on bond.
Yes, Your Honor, the state would oppose bond. And I paused, I figured the interpreter needed to interpret that. So the state would oppose bond?
Ok, l'État s'oppose à la caution.
And hold on. He is not a citizen of this country.
Il n'est pas citoyen de ce pays.
And therefore is a flight risk.
De ce fait, il est vraiment un risque de fuite.
And based on the facts of the case you have heard already,
En se basant sur le cas du dossier qu'il vient d'apprendre,
that are contained in the arrest warrant,
qui est contenu dans le mandat d'arrêt,
we believe he is also a threat to the community.
nous pensons aussi qu'il est aussi une menace pour la communauté.
And would request you deny bond.
Et nous demandons à ce qu'on refuse la caution, qu'on lui refuse la caution.
And that's all I have, Judge.
C'est tout ce que j'ai dit.
All right, I'll hear from defense counsel and what you would like me to know about your client.
Yes, Your Honor. In regards to what the state said, my client, Mr. Lenny, is not similarly situated. For the interpreter.
I'm sorry, I couldn't hear you very well.
I was saying, my client, Mr. Lenny, is not similarly situated to the others.
Ok. Mon client, Lenny, n'est pas vraiment situé en ce qui concerne ce cas.
In the affidavit, there is no specific facts about my client at all.
Dans l'avis, il n'y a vraiment pas un cas spécifique concernant mon client.
There are no facts that the state can point to say that my client poses any sort of threat to anyone.
Il y a vraiment rien qui indique que mon client pose vraiment une menace à qui que ce soit.
Because the affidavit only states that my client was part of the group.
L'affidavit dit seulement que mon client fait partie d'un groupe.
But it does not state that my client has done anything. It does not state that my client threw anything at anyone.
Ça n'indique pas que mon client a fait quelque chose ou bien il a lancé quelque chose à qui que ce soit.
And while I understand that the court is not considering the weight of the evidence at this time,
je comprends aussi que le tribunal ne considère pas le poids des preuves en ce moment-ci.
the court has been considering the seriousness of the circumstances.
Mais le tribunal considère vraiment le cas de ce cas, de cette circonstance.
And it would be hard to square away considering the circumstances without considering the actual circumstances and then the weight of the evidence.
Ok, vraiment, ce sera difficile de vraiment bien encadrer sans pouvoir prendre en considération le sérieux vraiment du cas évident de la circonstance.
As well as the factual allegations or lack thereof in the warrant regarding my client.
Il n'y a pas vraiment un fait d'allégation qui concerne mon client.
And additionally, while my client is a French citizen,
Alors que mon client est un citoyen français,
he came to the United States on a trip in order to improve his English.
il est venu aux États-Unis pour un voyage pour améliorer son anglais.
He saw a poster advertising the concert in the park.
Et il a vu un post qui fait la publicité d'un concert dans un parc.
And that's why he was in the area when the police suspended and arrested several dozen people.
C'est la raison pourquoi il était dans les environs, là où la police l'a aperçu et l'a arrêté.
in the United States legally,
Je voudrais aussi signaler que mon client est aux États-Unis légalement.
but even having an arrest, even if he gets out on bond, that would, as I understand it, his passport would be flagged.
I'm sorry, Your Honor.
I'm sorry, I was saying, as I understand, if you were, even if you were to be released on bond, his passport would still be flagged.
Même si je comprends que même s'il est libéré par caution, son passeport sera toujours en conservation.
Which would mean that he has a reason to stay in the area and return for his criminal case.
Cela veut dire qu'il a vraiment la raison de rester dans les environs et de revenir pour le cas criminel qu'il fait face, dont il fait face.
And as I believe one of the other attorneys had mentioned earlier, the criminal case, this criminal case does impose severe immigration consequences, even though my client is a French citizen.
I'm sorry, Your Honor.
I was saying, just the fact that he is involved in a criminal case does impose severe travel and immigration consequences on him.
Le fait, comme notre avocat a mentionné, le fait qu'il est pas à un cas criminel, ça impose vraiment un cas sérieux pour l'immigration.
And while I understand, Your Honor, that you're not looking to dismiss any cases at this time, this is something that I will be discussing, or one of the attorneys on his behalf will be discussing with the prosecution.
Je comprends aussi que, honorable, si vous n'avez pas, vous n'anticipez pas vraiment la défense sur ce cas, et c'est un cas qui sera discuté avec le procureur.
And additionally, I'd also like to point out the fact that my client has no prior criminal history anywhere.
Je voudrais aussi signaler que mon client n'a pas un cas criminel nulle part ailleurs.
And in fact, in France, he works as a supervisor at a high school boarding school.
En France, il était un superviseur à l'école secondaire. Et à l'école secondaire.
So his job is to essentially set standards for the youth.
I'm sorry, Your Honor. Please.
I was stating, so as part of his job, he is essentially a role model for the younger generation.
Okay. Et en se basant sur son rôle, c'est aussi un modèle pour la jeune génération.
And fleeing and not returning to court certainly doesn't square with those values.
Le fait de censure de ne pas se présenter au tribunal pour le cas ne correspond pas vraiment à sa valeur.
That's all I have, Your Honor.
C'est tout ce que j'ai à dire, mon honneur.
Mr. Johnson, anything in response?
No.
All right. I do understand your argument, counsel. However, I find his being a resident of another country is a flight risk at this stage, as well as no ties to this community, and the allegations support a threat to persons' property in this community. So, and I don't, this is not the place to dismiss charges. This is not the, I don't have the authority to sua sponte dismiss charges at a first appearance hearing. So at this point, I'm going to deny bond. You, in the meantime, can file a motion for bond before Superior Court, and we will set it down for a preliminary hearing, and you can speak with the prosecution in the meantime, as you mentioned earlier. All right?
Yes, Your Honor.
Thank you. I appreciate it. And is that your last client? Oh, I'm sorry, Mr. Interpreter, let me say all of that again. So I am going to, I find the defendant is a flight risk because he is a citizen of another country.
Ok. Je vous trouve comme étant quelqu'un de à risque de fuir parce que vous êtes citoyen d'un autre pays.
and a threat to persons and property in this community.
Et aussi une menace à la personne et aussi à la propriété, à la propriété et aussi de la communauté.
This is not the forum for charges to be dismissed.
Ça, ce n'est pas un forum où les accusations peuvent être classées sans suite.
Your attorney will be filing a motion for bond to be heard in Superior Court.
Votre avocat va introduire une motion pour une caution au tribunal supérieur.
And we will set your case down for a preliminary hearing.
Et ils vont aussi faire initier un cas pour l'audience préliminaire.
And in the meantime, your attorney may reach out to the prosecution with the information that she mentioned earlier.
Entre-temps, votre avocat va pouvoir contacter le procureur pour les informations dont elle a mentionnées auparavant.
So that will conclude your hearing at this time, and I'm sure your attorney will be in touch.
Ceci conclut votre audience en ce moment-ci et votre avocat sera en contact.
All right, and anything else for you on this calendar, ma'am?
No, Your Honor, may I be excused?
You may, thank you. And Mr. Oh, sorry, Mr. Johnson, were you trying to say something?
Oh, I was just going to say, and I believe that concludes my business as well. May I be excused, Judge?
You may, thank you.
Thank you, Judge.
All right. So language line, we've had a request, Deputy, if we could go ahead and do the Spanish case.
Yes, I asked them to transfer me to a Spanish interpreter already.
Thank you, ma'am. All right, just let me know when we have them on there.
Thank you for all that is customer service. Which language you need?
Spanish, please.
Thank you. Please call for your Spanish interpreter.
And attorneys, is this Mr. Martinez Noriega?
First ID 35593. I'll be your Spanish interpreter today. How may I assist you?
Good evening. This is Judge Davis with DeKalb County Magistrate Court. I have a first appearance hearing with a Spanish speaker. Are you able to assist us with that?
Yes, Your Honor.
All right. Could you please raise your right hand for me so I can swear you in? Do you solemnly swear or affirm to correctly, truly, and accurately translate from French to English and from Spanish to English and English to Spanish to the best of your ability?
Yes, sir.
Thank you. Could you please introduce yourself to Mr. Luis Antonio Martinez Noriega and make sure he can hear and understand you?
Señor Luis Antonio Noriega, es intérprete de español del día de hoy. ¿Puede escuchar? Yes.
Thank you. You can start translating for me now, please. This is your first appearance hearing and is not the trial of your case.
Esta es su primera aparición, este no es el juicio del caso.
This is an informational hearing to make sure you understand the charges against you, to advise you of your rights, and to consider bond. Sorry, okay. This is an informational hearing to make sure you understand what you are charged with.
Esta es una audiencia informativa para que ustedes entiendan los cargos que se les están asignando.
To advise you of your rights.
Indicarle cuáles son sus derechos.
And to consider bond in your case.
Y considerar fianza en su caso.
I'm not here to determine whether anyone is guilty or not guilty.
Yo no estoy aquí para determinar si alguien es culpable o inocente.
Please understand that this hearing is being broadcast over the internet and also being recorded by the court. I'm going to inform you now of your rights in any criminal case. You have the presumption of innocence unless and until the state proves the charges against you beyond a reasonable doubt at trial or until you enter a guilty plea. You have the right to have a jury or a bench trial, and at that trial, the state has the burden to prove every charge against you beyond a reasonable doubt. You have the right to call your own witnesses at trial and to introduce your own evidence. You have the right to testify at trial. Well, I'm sorry, let me add this. You have the right to use the subpoena power of the court to compel witnesses to court. Do we still have, are you there?
Yes, can you hear me?
Yes, I can hear you better now. You were breaking up earlier. Please let him know that he has the right to use the subpoena power of the court to compel witnesses and evidence to court.
Tiene usted derecho al poder declaratorio del tribunal para obligar o hacer que personas aparezcan en el testimonio o
You have the right to testify at trial, but it can be used against you and you can be cross-examined by the state.
Tiene usted derecho a testificar por su propia cuenta, pero puede esto ser utilizado en contra y puede ser examinado por el Estado.
You have the right to remain silent, and that silence cannot be used against you.
Tiene usted el derecho a permanecer en silencio y ese silencio no puede ser utilizado en contra.
You have the right to be represented by an attorney, and if you cannot afford one, one will be appointed to represent you free of charge.
Tiene usted el derecho a ser representado por un abogado, porque si tiene para pagar un abogado, puede que se le asigne a uno y le dejar.
You also have a right to a preliminary hearing, which is the next hearing you may have.
También tiene derecho a una audiencia preliminar, puede ser.
That hearing is just to determine if there was enough probable cause to arrest you.
Esa audiencia sería solamente para determinar si es suficiente causa probable para arrestarlo.
At that hearing, you and your attorney will be able to cross-examine the state's evidence.
En esa audiencia, usted y su abogado van a poder examinar la evidencia por el Estado.
If your case is bound over, well, no, strike that. If there is enough evidence, your case will be bound over to Superior Court.
You were breaking in and out, Your Honor. Would you repeat it for the jury?
Yes, if there is enough evidence, your case will be bound over to Superior Court.
Si hay suficiente evidencia, eso va a llevarse a un tribunal superior.
At that point, the prosecutor may formally charge your case.
En este momento, el fiscal puede cargar su caso.
And then you will get an arraignment date, which will be the first chance for you to enter a plea and get a jury trial date set in your case.
y recibió cierta una audiencia de adjudicación donde se le veían sus cargos y esta sería la primera donde se puede.
When you get out of jail on bond, you generally waive your right to a preliminary hearing. If you are convicted of any felony offense, you face a minimum of 1 year to a maximum of life in prison, depending on the severity of your charge.
Si usted es condenado a los cargos, usted puede pasar el mínimo de una sentencia de
Some or all of that may be served on probation.
todo eso puede ser ejecutado en libertad bajo libertad probatoria.
If you are convicted at trial, you have a right to appeal that conviction.
Si es usted encontrado culpable en el juicio, usted puede intentar.
All right. Sir, you are charged with warrant numbers 23W003576 through 79.
Señora, usted cargado con las órdenes de arresto 23W573.
The charges are forgery in the first degree, the charges are forgery in the first degree,
Los cargos son falsificación en el primer grado,
unregistered vehicle,
vehículos sin registro,
no tag, no, yeah, it was no tag,
sin paquete,
failure to maintain insurance,
fallar al mantener seguro,
and failing to obtain a Georgia driver's license.
y fallar en obtener una licencia de conducir de Georgia.
Ms. Cabrera Alvarez, have you had a chance to go over these warrants with your client or someone from your office?
Yes, Your Honor.
Mr. Interpreter, you can interpret my question. I'll ask it again. Ms. Cabrera Alvarez, have you had a chance to go over the charges with your client, or has someone from your office had that chance?
Señor Cabrera, ¿ha tenido la oportunidad de discutir con su cliente o con un representante de su oficina?
Yes, Your Honor.
Sí, señora.
And are you waiving a formal reading of those charges into the record?
Y oficialmente están eximiendo su derecho para ingresar en sus cargos.
Yes, Your Honor.
Sí, señora.
So, sir, do you understand the charges against you?
Señor, ¿entiende usted esos cargos en su contra? Yes.
All right. I understand the attorneys. Have y'all reached a consent in this case?
Este es el abogado que le